You were born free, but the moment you were registered as a 14th Amendment citizen, a silent contract began. One you never saw, never signed. This isn't fiction, it's law. Let me show you how you became the collateral. In common law, you are sovereign, a man or woman of inherent dignity. But in commercial law, you're not you. You're a legal fiction, a person, created when your name was registered at birth. That registration formed a trust estate in your name. You, the living being. The estate, the legal entity. And here's the trick. They presumed you abandoned the estate. Without your claim, the state acts as administrator, and you're treated like a ward, an infant trustee and chattel property of a decedent estate. In 1933, the U.S. declared a banking emergency, and, as shown in House Congressional Record, March 9, 1933, page 83, the government couldn't pay its debts. So what did they do? They mortgaged you. Through House Joint Resolution 192, gold was confiscated. The gold standard was removed, and the American people, their labor, property, and estates became collateral. Every birth certificate became a bonded security, used to back currency, traded on markets, tracked through your social security number. Your estate became the trust, and you became the surety. Your birth certificate became a bond, your labor and estate collateral for a system that treats you like property under federal territorial jurisdiction via the 14th Amendment. This federal citizenship, however, is entirely voluntary. Today, administrative agencies don't operate under the Constitution. They operate under commercial law enforced in courts of equity, not common law. That's why you're fined, taxed, and regulated without ever facing a jury. Because you're not seen as a living sovereign, you're treated as a legal person under administration. The laws that bind you aren't passed by Congress. They're regulations enforced by private administrative bodies. IRS, DMV, EPA. They govern persons, not people. And remember, a person in law includes corporations, infants, even decedents. Unless you reclaim your role as lawful heir and executor of your estate, you'll continue being governed as property, but you are moved into commercial law, where silence is consent and all property is pledged. To escape the indenture, you must correct the presumptions. Claim your estate, declare your status, re-enter the lawful jurisdiction, where people rule, not persons submit. You must rebut all presumptions on the public record in your county, and then serve all interested parties, giving them the opportunity to lay superior claim, which they cannot. Break free from this indenture by claiming your estate and stepping back into the realm where people, not persons, hold power. Learn how to be part of the solution by searching Burn the Corporate Fiction on YouTube, Rumble, Facebook, and X.
Wow, put me over on the... Well, I'll fix that in a moment. Welcome to Burn the Corporate Fiction, ladies and gentlemen. Hope everyone is having an excellent evening. I suppose I can fix this little mess up. I don't know why StreamYard, for the amount of money they charge, always messes something up in the beginning, it seems like. So we'll take that back off. There we go. There I am. Okay, fantastic. Anyway, good evening, everyone. I hope you guys are having an excellent night. Tonight, I figured what I would probably do is go over... So I've been talking about the problem, you know, what the problem is. That short I just showed pretty much sums it up, right? All of these presumptions and contracts that have been unknowingly placed on you, right, through, you know, coercion, misrepresentation of material facts, among other things. You know, you're misled by agents of the state to believe that signing up for Social Security, registering your child, all these things were mandatory, when in fact they're voluntary. Okay, and we've actually been territorially occupied by international bankers and a hostile foreign corporation known as the United States. Not the United States of America, which is the geographic collection of several states in a union, but the corporate United States, which is the District of Columbia doing business as the corporate United States. So the purpose of tonight's stream, and anybody's welcome to come up and ask questions or contribute to the conversation if they want. I've pinned the link in the chat, but the point of tonight is to show you guys what we do in the Jurist Society and why it works. Okay, why it works. So what is the one thing that you're always trying to do when you enter into the courtroom? Is you're trying to challenge their jurisdiction. If you go into the courtroom and you let it get past arraignment and you're arguing with these people, or just, having what they call a trial, and you're trying to say, well, I have the right to travel, I have the right to do this, I have the right to do that. What they know, and what you should know by now, is that is not the case. If you are a 14th Amendment citizen, you don't have the Bill of Rights. The only part of the Constitution that applies to you as a 14th Amendment citizen is the 14th Amendment. And what I like to call it is a contractual black hole, okay? Where it's basically the underlying contract where you accept the benefits, privileges, immunities, and benefits from the federal corporation, and in exchange, you administration. They take care of you and they protect you because you become their property. Somebody posted on the channel's Facebook, or not on the channel's Facebook, but somebody who follows the channel's Facebook post, he said, "Do you know that marriage licenses came about," and this is true, to regulate interracial marriages when somebody wanted to marry the newly freed slaves that had become 14th Amendment citizens. You had to go get a license to marry one of them. Now, people would automatically assume it's because of the interracial aspect, but it is not. It absolutely is not. It is because the slaves were formerly private property, and then by adopting the 14th Amendment Citizenship Trust, they became public property. So you still needed to ask their owner for permission to marry them. And then, of course, the intention behind that, just like everything else with the 14th Amendment, was to expand that to everybody. And by 1929, everyone had to have a marriage license to be married, and the state is now a party to your marriage with a claim to the product of the marriage, which is the issuance, the children, right? So you're basically a business partnership. But I am digressing. That's just one example of the many things that have been changed in society as a result of this corporate indenture, this coming under the federal corporation. So, all right, let me say hi to the several of you that have showed up already. We have Valley Parks, LJ. Valley Parks said that they're working on their will right now, which is fantastic. We have Chicago Cubby Bear. Good to see you. Benji Boodles, Jonah Foz, and I think I see Mojo Shop in there. Good to see you, man. El Piro, good to see you. And Roger Ledwell, if I had not mentioned you, good to see you, man. So, all right, without further ado, of course, I'm not going through the whole claim. I have removed the sensitive information from the claim that revolves me. Everybody knows my name, so that's not really a big deal. But, like address and the various account numbers associated with the trust that you have to put in there for identifying the trust and pointing out what it is that you are claiming your property from, it being that trust that they created. And so, and again, the link is in the chat. It's pinned to the chat. If you guys want to come up and contribute to the conversation, you are more than welcome. So, all right. So the title of this is a lawful claim of title, will, execution of will, declaration of status, appointment of trustees, and standing orders for the same. So I created a header up here, right? On and for all public and private records, for all courts, and for the House of Wells, because I keep my own court. And this is what happens when you reclaim your sovereignty. I've explained this before, that the sovereign authority to hold court is borrowed from us. And just because the government is vested with a portion of our sovereignty to be able to hold court does not mean that we have divested ourselves of that ability. You can still hold your court, and every court of record, which is a common law court, must have a seal. So that's the other aspect of this, is the declaration, establishment, publication of the House seal, which I didn't actually pull up, but why not? I guess I can real quick. Just so you guys can kind of see what this looks like. And these are the two most important things that you can do to claim your estate on the record. And the seal is very important at common law for several reasons. One, it protects against fraud. Two, it bears its own consideration, right? Which means it bears its own proof. It stands as its own evidence, right? It is literally a political house. It is a state unto itself. And that's really what a state is, was a collection of houses that agreed to stand together within one common boundary for economic prosperity and mutual defense, right? The state itself is not the government. The government's only sovereign because the people within the state are supposed to be sovereign, right? It's actually the state itself is the people and the collection of houses. And each house is the very first political subdivision of a state. So you have to have a house. That's actually, since they've presumed everyone to be, as one of the people, to be missing and dead, or, presumed, or missing, presumed dead, as one of the people. And then as a 14th Amendment citizen, you're an infant trustee and chattel of a decedent estate, chattel property of a decedent estate. You can't hold title or make decisions or have a house. So what they do is, part of what they use to take out loans, appropriate against your sweat equity, is the housing under development, or the housing and urban development. You're considered a house under development. And what they mean by that is, yes, they use it in both senses. They talk about actual housing, but it's also meant to cover the aspect of the house that is your family, right? Your house is your very first political protection against any kind of encroachment from another house, or pretty much what the government is that's just one big house. That's why it's called the House of Representatives, right? It's a house. So it's your very first line of protection against any encroachments by anyone else, including the government. So let me see if I see declaration, establishment. Yeah, pull this up too. Or is it in my documents? There it is. I think this is the finished one. It should be. So I'm going to pull this up too. All right, now let me just stop this. I'll show you the other thing. So this is actually what you do before you even put your claim on the record. You have to put your seal on the record and establish the seal. Okay, so we'll go through this first real quick. Yes, fonts and sizes do matter in the claim, Benji asked. They do matter in the claim because that's the only thing the clerk can control, is the spacing, font size, the borders. They cannot control, they ministerial, and this is the law. I have a notice of liability, or a notice of demand to file already printed up, where it cites all the law that tells them that their duty is ministerial, and they only have the ability to dictate the format of the document, but not the contents. That's a fact. So as long as you look up your local county clerk or your local county register, and it'll tell you what the requirements for the document have to be in order for them to file it. They cannot tell you, though they will try sometimes, tell you what can be in the document. That's not their business. The public record is yours. It's a public utility. We pay for it. It's there for you to effect title to property, and you do not need the government's permission to do that. Okay, if an instrument is no good, then when you try to use that instrument outside the public record, it'll be handled in court. This instrument, there's nothing the court can do with it. So let me show you guys this real quick, and then we'll get back to the claim. All right, so good evening, Theo. This is the Declaration, Establishment, and Publication of House Seal. So basically you say, it comes now, Ryan Mason, House of Wells. It's a common law way to write your name, because your name is actually just your first and middle name, hyphenated, right? Your last name, or what the Romans called a surname, which they introduced in this country through the Napoleonic Code in Louisiana in like 1803, I believe it was. The surname is a Roman thing, right? We have essentially a common law. We have clan names or house names, right? And that's not part of your actual name at all. It's just the house that you're a part of, that political subdivision that you belong to, right? So comes now, Ryan Mason, House of Wells. One of we, the people of the state of Michigan, having been found to be living, being of sound mind, competent to give testimony, and having come to full age, donor, grantor, testator, sole lawfully appointed absolute general, instituted rightful executor, and sole lawful living heir of the Ryan Mason Wells estate, as well as all derivative names, spellings, items, sonins, means things that look or sound the same, right? and trusts thereof, born on the land in the state of Michigan on the 7th day of November, 1989, hereinafter referred to as declarant. So you do that, and you go hereinafter referred to as declarant, so that it shortens up. Now, every time you use the term declarant, it includes all of this up here. Okay, so now all I have to do is just say declarant, right? And basically the point, and I'm not going to go through the whole thing too in depth, but the point of it is the seal embossed upon this document under the label Figure 1 is hereby created and established as a mandatory addition to the signature of declarant and must be embossed as a raised seal appearing next to, above, or below the signature of any document to which declarant is a signatory to be legally binding under any circumstances. No one else may use or copy the seal of the House of Wells without express consent from declarant. Okay, you have the absolute right to create your own house seal, 100%. And so, for instance, the first governor of Indiana, I believe it was, I have the document, but I've shown it before. But anyways, the first governor of Indiana, when he was going to become, when they set up the schedule for how the governor was supposed to take office and what his seal would be and all that type of stuff, they said, whoever is elected governor shall use his private seal until a seal for the governor can be made. And so what that tells you is they didn't know who the governor was going to be, but automatically they knew that that governor would have, that person who would be eligible to be governor would have a house seal. Okay. And so you have to have a seal. It protects you against fraud, and it gives validity to your instruments. Okay. So that it basically acts, I mean, you still need a notary in some circumstances, or witnesses, a quorum of witnesses stand in lieu of a notary. But we got Sergeant Frog Dog in the house. Good to see you, man. So so basically what I said is, due to the fraud mentioned above, declarant shall not be considered a signatory, no bound by any document or contract created prior to or after the date of this declaration, which does not bear the signature of declarant accompanied by the embossed seal of the House of Wells. So what that does is it casts the shadow of doubt on all prior documents that you are presumed to have knowingly entered into, all contracts that you've been presumed to knowingly enter into. It casts the shadow of doubt on those things, right? Because you have to look at it like this. Prior to you claiming your estate, you were beyond the sea, and there was an infant trustee managing the affairs of the estate. Okay, that's an entirely different legal person than who you are becoming now, or who you are, you claiming your estate. Now you are of age and you take rightful control of your estate, because so it's an entirely different person coming back. So you can do this. You can be like, well, listen, whatever the estate has been presumed to have been entered into, if it doesn't have this seal, then it's void, right? And any document without the signature and seal of declarant as affixed below shall be presumed as having been entered into by deception through misrepresentation of material facts under coercion, duress, protest, and or without declarant's knowledge or consent. So that's the point. All such documents shall therefore be void, legally unenforceable, not binding, and shall have no other standing than that of being proof of fraud perpetrated against declarant. This is highly important. Okay. We got Chicago Cubby in the house. What's up, Chad?
Hey, how's it going?
Not bad, man. Not bad. Let's see here. It says any individual, government, company, corporation, man, woman, or any other entity that may have interest in this matter and wish to dispute the validity of this declaration or any portion herein must do so within 30 calendar days from the date of the recording of this declaration. Now, the reason that's in there, and it's in the claim also, is what makes it the highest form of evidence at law, because you're going to put this on the public record, which is necessary for claiming abandoned property or doing anything. This is how common law works. You put it on the public record, or, I mean, for abandoned property, you could also put it in a newspaper or any kind of government or state publication, and that would count also. But the public record, right, anything that's on the public record and stands unrebutted stands as the highest form of evidence at law. Okay, so what you do is after you file this and you file the declaration of claim, or the lawful claim of title, then you serve all interested parties, and they have 30 days to state a superior claim or object to your filing, right? So, and if they do not, then that's considered consent. That is considered agreement. that is considered okay, well, there's nothing we can do. We have no superior claim. So, okay, well, I have this registered certified mail, right? I have this, registered mail or certified mail, however you send it to them, that shows that I served you this. You had 30 days to rebut it. You didn't rebut it. And that's the very simple point of it, right? So then down here, figure 1 right here, you put your seal over here, sign here, and then you have 4 people or 3 people and a notary signing underneath, but you do not have the notary use their seal because it will be a counter deed to your seal here. So the notary merely signs it as an agent of the state to show that the state recognizes and acknowledges it, not as permission, but it just shows the states acknowledge it. Okay. So Valley Park's asking me something, are you? Hold on. Let me see. Sorry, I didn't see that there. Your family wants you to do a life estate. I feel pressured. Okay. Why do you feel pressured? Going to the notary tomorrow. Okay.
I think Benji had a question too there.
Okay, what's the question? Let's see here. He says, is there a way to see who else has claimed estate on the record? Can we see who in our county knows what's? Yeah, absolutely. It's public record. I could give anybody here my public record number right now, and you could go to the Muskegon County public record, like the Muskegon County Register, and you can look up my public record. And you can even print off a copy. You got to pay for it, but you can print off a copy of my public record because it's a public record. That's what makes it binding, and that's what makes it the highest form of evidence at law, is that this is notice to the public, to the public, right? That I am now private, basically. And so here I'm going to serve everybody interested, right? Who thinks I have an interest in my estate, and I'm going to give you 30 days to rebut what I'm doing, to object to what I'm doing, and give me a what's the word I'm looking for? State of superior claim. Sorry, that's the point. State of superior claim. So, and they will not be able to. And we're going to go through the claim a little bit to show you why. And they cannot. And in fact, when you send people this claim that I'm going to show you, they shit themselves is what happens. Okay. Because it's also a vicious performance contract. So, let's see. Let's hide this comment. Let's see what Sergeant Frog Dog says. I use this process when reclaiming my MCO for my Ford truck, which is the allodial title for the truck. I was able to get a compliance letter directly from Ford, lawfully reconstructed the MCO private title declaration, and recreated the MCO. Boom, exactly. Right. You can send this claim to creditors. You can send this claim to anybody who is administering your estate, because all of what they're doing, when you understand what they're doing in this system, where they're taking your signature and they're securitizing it, right? And they're using that as the source of credit and acting as the middleman to allow you to access your own. They're not giving you anything. You're not buying any, or you're not getting a loan for anything, not for a car, not for nothing. You're not getting a loan. They're giving you nothing, right? What they're doing is instead acting as a middleman to allow you to access your own credit, basically, and then charging you interest for it and penalizing you and placing your property. And somehow they claim to have the right to lien the property and repossess it, or whatever they want to do, if you default on the loan, even though they gave you nothing. It's insane. Do you understand what I mean, Chad?
Yeah, I was just about to ask, is that on every loan? Like
Every
pretty
single,
much?
yeah, because you got to remember that the mortgage of your estate is what makes the Federal Reserve note, what makes all commercial paper in this country valuable. The only thing that makes it valuable is your future sweat equity, right? And that's represented by the Social Security Trust. And so anytime any company, whether it be the cop on the side of the road or a creditor, any kind of creditor, which they're not really the creditor, you're the creditor as one of we the people. That's the whole thing. They're just standing in lieu of you as one of we the people. But anyways, so if they can create an attachment to your estate, then they can generate their own commercial paper. And that's what mortgages are, car loans, traffic tickets, bonds. All of these things are commercial paper that they can generate once they get an attachment to your trust estate, and as security for what they're doing. So it's guaranteed by your sweat equity. Because all of these things are dead entities. Everyone's dead entity, including Even the estate technically is a decedent estate, but it's the trustee and the guarantee that the trustee will perform the obligations placed on the estate that gives anything value, because there is no money. And I know it's a little confusing at first, but do you kind of get what I'm saying now?
Yeah, yeah. Do you think that they would ever like truly get rid of Social Security, or you think that's just something that they hang over everybody's head constantly to keep them on the leash, basically?
Well, what they wanted to do was bust the Social Security to destroy the economy and completely enslave everyone, and that would be how they get rid of it.
Mm-hmm.
But Social Security itself is nothing but a nexus for them to tie all of your property and labor to be able to tax you, to be able to generate revenue from you. The Social Security itself is it's just a deferred retirement benefit, but you notice how you have to have a Social Security number to get a job. You have to have a Social Security number to get a car. You have to have a Social Security number, to get a license.
It's tied to everything.
It's tied to everything. It's tied to everything. And that's because they mortgaged your estate in 1933. So in order to make that mortgage actually workable in this system that they're doing, they had to create an account to tie all of your future property to, and all of your children and all of your children's property to. And that's what the Social Security Trust actually is. It has nothing to do with wanting to make sure you're taken care of when you're retired. No, it's a way to evaluate your entire life before you've lived it.
Dick Wayne was asking, can this process be followed as a Canadian? I'm not quite sure if you would know the answer to that.
Well, here's the thing. It's a little bit, it's probably not as easy in Canada as it would be here. And it looks like we got Mike as a new member of the Jurist Society. Excellent. We'll be meeting tomorrow night at 9 or 9:30 actually. And we meet 3 times a week, and we're going to be going over private express trust. But and that's the second part to this whole thing. After you claim your estate, then you want to put your property into a private common law trust. That's exactly what the Rockefellers, the Rothschild, that's what all of these people do. So to answer the question from Canada, any common law country, this is possible. This is doable. The question is how far gone is it from common law? Like, we're not that far removed from our common law roots here in the United States. They only got everything switched over about 50 years ago. Okay, that's when they got everything switched over from common law, blended everything, maritime and civil, admiralty and civil law, blended equity and law itself together and all that, and just made one hodgepodge of a commercial jurisdiction because everyone became a trustee of the estate. So let me see if I can explain this in a logical, chronological manner so that people can get it. So in order to have lawful rights to property enforceable at law, one, you have to be sovereign, not indentured. You have to be one of we the people, right, of the states, and not be under the administration of the federal corporation in exchange for civil rights and benefits. So I hope everybody understands that. So the 14th Amendment citizen is automatically indentured by the virtue of what that trust is. That trust was created for the newly freed slaves who could not act as one of we the people because they were not independent, and they also were just formerly private property. So the public trust was created to make these people public chattel, right? And the reason that the United States corporation said they were making them public chattel is so that they could then protect them and offer them privileges and immunities known as civil rights, so that nobody could take advantage of them or indenture them or whatever the case may be in the future. But they were not free. And they didn't become free. They just went from being private property to public property. They went from private chattel to public chattel. And the real reason that the United States corporation did this was to have a pool of collateral to borrow against. Because now those 14th Amendment citizens are capital stock. They can take out agricultural loans against the capital stock because they're under the administrative control of the federal corporation. We, the people, have never been under the control of Congress or even the state. Only fellow citizens, fellow people, could bring you under any kind of authority, and that took a grand jury indictment, right? It took a signed sworn affidavit, and it took witnesses to make that happen. And then if you wanted a trial, and guess what? The judge had no power in that trial. There was no judge. It was a magistrate or a justice of the peace. In a court of record, there's no judge here in the Republic, in the United States, right? Not in a common law court. And so there's not supposed to be. It's supposed to be a justice of the peace. So anyways, what ended up happening, of course, that changed pretty quickly by the early to mid 1800s. But originally, when the country first started, that's how it's supposed to work. So the only people that could bring you to heel for anything is other fellow sovereigns. The state couldn't just the county, the state, no corporate entity, no non-living entity could just claim injury, right, and drag you to court. There's a huge process that was required. And the purpose of me saying that is so the 14th Amendment citizen is already under administration. Okay, so in order to have lawful right to your property, you have to not be under administration, because then you're like an infant. And then secondly, you have to have money. You have to be able to buy and sell. Okay. Mm-hmm. There's no money. That's how they locked everybody into a trust indenture. So when you buy something and you own it outright, like Sergeant Frog Dog was saying about having the MCO to his Ford truck, he owns that. And that's enforceable at law because he owns it. He doesn't have equitable right to his truck anymore. He has lawful right to it. See, equitable right is a condition that's dictated by some sort of contract or trust agreement.
Yeah, he ain't tied to that third party.
Yeah, and so and you can't enforce that at law because it's pretend rules. It's made up stuff. It's man-made stuff. It's at law, in reality, in fact, there is no such thing as a trustee at law, right? This is a legal fiction. Okay, usufructuary situations are legal fictions, and law is not going to deal with it. Okay, all of this stuff has to be adjudicated in equity because it's all man-made contract stuff. The contract makes the law, and this, you know what I mean? But in order for that to be law, so if you and I enter into a contract, right, that becomes the law for both of us, and whatever property the contract regards, we each have equitable right to that property because it's under privity. Two of us have interest in it, and that's where the word privilege actually comes from, because two or more people have interest in it, and that contract is the law for us regarding that property. Now, Sergeant Frog Dog comes over, and the laws we made have nothing to do with him. Doesn't matter unless he's on or using the property that's affected by the contract. But other than that, we can't enforce our private law on him unless he becomes a party to the contract. That's the difference between law and then administrative regulation, statute, code, and all the other stuff. All the other stuff is man-made stuff that requires, unless it is in concordance with the law, unless it lines up with the law, then it requires your consent to take the color of law and be enforceable against you. Like Sergeant Frog Dog says, mine. Yeah, his Ford's his. And there's nothing anybody can do for it. And I bet you he's beaten every ticket they've tried to write him, because they can only regulate their property. They can only regulate property under administration. That's why we're claiming our estate, first and foremost. That's why we create our seal and declare our house to exist in our house seal, and we create that layer of political protection, and then the claim. Now, you guys are going to see why the claim is so effective, and why when you serve somebody like Sergeant Frog, when you serve Ford or something like that, hey, I need my MCO. Are you trying to administer my estate? See, because what Ford wants to do is they want to take that actual MCO and they just want to send it right to the Secretary of State that issued the license. And then the Secretary of State's going to keep that MCO, which is actually the allodial title, and issue a certificate of title, which just shows that Sergeant Frog Dog has an equitable interest in the Ford truck, but he doesn't have the absolute ownership interest in the Ford truck. So that his rights and his ability to use that truck are going to be dictated by the contract, right, that governs that property. And that contract would be the driver's license with the state that governs you using the state's property. So Sergeant Frog Dog didn't do that. Sergeant Frog Dog claimed his estate and then sent forward and said, hey, look, you're not messing with a 14th Amendment infant. I'm one of we the people, and if you try to administer my estate, I'm going to sue the shit out of you. And boom, they send him his MCO. Just right, that's it. Because they're not messing with it. They know they can't. And what would be administering the estate? Taking my property, taking title to my property, and sending it to somebody else on my behalf without me telling you to, without my permission, without my knowledge or consent, right? So that's administration. The credit bureaus are administering your estate. Credit card companies are administering your estate. all these, they're accessing your trust, right? They're accessing trust to securitize your signature, and then acting like they're loaning you something. They're not loaning you shit.
So when you get something notarized, you're just basically bringing administration into the equation too, correct?
Not always.
Okay.
So notaries have existed even prior to this system, and notaries basically are like a public service that is a unquestionable witness to something, anything, like a document being signed, wherever the case may be. It just gives validity to it. But a quorum of witnesses would also do the same thing. So in my documents, what I did was I made it a quorum of witnesses with a notary, but the notary, I didn't let the notary use a seal, because then they would counterdeed my because my seal is on it. Yeah. So I didn't want the state to be a party to my claim. I didn't want them to counterdeed my claim. So I only have my seal on the claim. And then I had the notary just sign it and put their, all their notary information. And then, hey, don't you seal that. It's already sealed. Right. So, all right, let me pull up this claim again. All right. Here we are. Share screen. What Benji say? He says, I'm 40 and I never got a credit card. It is a scam. It's
Me either, Benji.
Yeah, we got Sarah G just showed up. Good to see you. Good to see you. All right. So, and what El Piro say? Medicare qualified government employee. That means one must be a government employee. You got a state ID or driver's license? Absolutely right. That's 100%. All these account numbers linked to your Social Security trust account. That Social Security trust account is the property of the United States corporation. They made that. They made that trust, that legal fiction, for you to adopt if you wanted to. You do not have to. And you can also claim it back once you find out what's going on, because of the way that they have gotten you into the situation in the first place. Is every equitable maxim that violates a contract, right? So fraud vitiates contracts, all contracts. That's law and equity, right? And so coercion, fraud, coercion, collusion, and misrepresentation of material facts. You can look at it from the aspect of when you were a child going to school, agents of the state, the teachers, right, had misled you into believing you had to sign up for a driver's license and sign up for selective service registration, sign up for all these things. You were misled by agents of the state, right? Misrepresentation of material facts, that's fraud. The coercion that the cops are constantly engaged in, threatening to seize your property if you don't give the controlling interest of it to the state to be used as collateral for a debt, for the debt of a foreign corporation. That's slavery. There's Supreme Court cases that say a state cannot force one person to pay the debt of another. That's slavery. Cannot do that. Well, that's what they're trying to do. So when you know what they're doing and know how to prove it, it absolutely vitiates any contracts that they presume to have with you. The way that you effectively do this is you get that on the public record, and then you serve them. Look, this has a public record number. It is on the record for all to see. This is not like something that I did not disclose to the public, and you were served with it. I served all interested parties, and you did not rebut it. You did not object to it. You did not lay a superior claim. So this is the highest form of evidence at law that you agree with it because you were served with it. And you had 30 days.
Okay, I was about to ask 30 days. Okay.
Yeah, so I'll show you. So right here, and like I said, I eliminated the sensitive information. So it comes now, Ryan Mason, House of Wells. That's how you write your common law. You guys notice that you can either use a semicolon or a colon. It doesn't matter. And then it's your last name is not a name at all. It's not your name. It's your house. It's your house. Okay. A man having been found to be living. Oh, and the lady at the clerk's office, she sent my document back to me, and the envelope says Ryan Mason, House of Wells on it. So they addressed me properly and everything. They know what the hell is going on. So a man having been found to be living and of lawful age, a living soul manifest, one of the people of Michigan. Now, why did I start that off right there? Having been found to be living and of lawful age. Well, that's the very first presumption, because there was a period of time in this country when people were dual citizens. They were state and federal citizens, and they enjoyed the protections of both. And that kept the federal government at bay to a certain extent because they could not transgress the their rights as one of we the people. That's why they had to eliminate that other standing of state citizenship and bring you under federal citizenship entirely. And the way that they do that is presuming that you assuming that you are missing presumed debt, unless you state otherwise. And that goes back to the Set the KV Acts, all of them. And that's why those were written in the first place, was to allow the government to, it's called escheat, right? escheat. Escheat is when somebody dies without a will and the property immediately goes to the government for administration, because no property shall go to waste. It's called escheating. Look it up sometime. Michigan had an entire board of escheat. Right, they established an entire board of escheat to just start taking all the property in mass as people started, becoming more and more ignorant.
So
and
does that? Oh, sorry.
Go ahead. No.
I was just going to say, does that apply to, like, so somebody dies, they don't have somewhere to pass on things? Does that apply with, like, mail? Like if they have mail or anything like that? Do you know?
Wait, say that one more time. Just one more time.
Say somebody similar to the estate. If you ain't got anybody to pass it on to, like, if somebody still had mail coming to their house and they're dead, they're deceased or whatever, is this similar to that too? Like you say property, I mean, would that be considered their property still, or how does that work? Do you know?
So yeah, that's the whole thing. So they'd find out that person, once they found out that the person's no longer living, if that person does not have a will, right, then automatically it comes under the administration of the state. So there's two different positions, controlling positions in a trust or dealing with an estate, right? And one is the executor. The executor is appointed by will. That's what you do in this document I'm showing right now, is you appoint yourself as executor, because you can. Why do you do it? Because the other position is the administrator. Okay, and administrators are basically an executor, but they're not called executor because no one appointed them by will. They were appointed by operation of law because there was no will. That's what the judge is doing every time you come into the courtroom. He's trying to act as a special administrator. He's trying to administer your property. He's trying to bring you in, compel you to answer for this your use of the Set the K trust, your misuse of the property. And he's trying to generate his own commercial paper using you as the security and create an entirely new trust using you. That's called a judicial. It's called a judicial mortgage or judicial trust. And that's what happens when you get put on paper and you're required to perform obligations like probation or pay a ticket or do classes or whatever. That's a whole new trust indenture. He's administering your estate. He's acting as a special administrator. Does that make sense? Like, so for instance, in Georgia, the entire traffic court of Georgia is under probate. Probate deals with traffic. And why does probate deal with traffic? Because probate deals with estates, decedent estates, abandoned estates. That's what probate's area is. So this whole nation is considered to be a bunch of abandoned property that's being administered by these trust companies. That's what's going on. Everything basically considered abandoned and under the administration of the corporate state. We got Crip Rick showed up. Good to see you. And who else said hi? Yep. Okay, cool. It was him. All right. So that's why we say we've been found to be living and of lawful age. Now, here's the other presumption, is that you as a United States citizen are an infant. Now, the funny thing about infant, the word infant, and I'm going to stop sharing this for a second, is people think infant means child. It doesn't. It means somebody who's legally incapacitated. Okay, that's what it means. Like, for instance, you call when people become property of the army, what do they call the main corps of the army? Infantry.
Yeah, sorry. Yeah.
Well, it's so you're presumed to be property and have no actual lawful capacity to enforce your will is what's going on. And infant, so let me show you. It's even in Blackstone's. Hopefully it's still up. It probably won't be because I want to show it though, but because that seems to be how this browser does me sometimes.
I wonder if that's why they make the infantry the front line.
Maybe.
Gotta get rid of the stupidest ones first.
All right, Blackstone's comment. Okay, so here we go. I'm going to show you guys Blackstone's commentaries again. This was written in the 1760s. And by then, in this book, if you read it, he talks about how Roman civil law and equity were overtaking common law. and what a big problem it was, right? So you see this, he's talking about this is incorrect, or he says, to the 21 or to the 1 and 20th year, and until then the young remain under guardianship. Okay. This is also the period when the king, as well as the subject, arrives at full age in modern Sweden. He says, this is incorrectly expressed. First, the infant is sued in his own name alone, as any other person, but he appears to defend his cause by guardian, being supposed without discretion to appoint an attorney for that purpose. He does not necessarily appear by his regular guardian, as the text implies, but by any person whom the court shall appoint guardian ad litem. Okay, so that's at law, right? Now, when you go down here, this is why they switched everything over to equity. Okay, he tells you, where is it at? Okay, an infant has been held to be liable for a fine on his admission to a copyhold estate. Well, that's what they've done with the all caps name. That's a copyhold. I'll have to do a show on that at some point. But on his admission to a copyhold estate. But it has been said that if an infant is the owner of houses, well, wait a minute. How would an infant be an owner of houses, right? It is necessary to have them put in repair, yet the contract to repair will not bind him at law, for no contracts are binding on an infant, but such as concern his person, right? So that's why this is one big reason why they switched it from law over to equity. But in equity, an agreement by an infant to pay compound interest on a mortgage to prevent foreclosure is binding. Right? So when you're in a trust as a trustee, it doesn't matter what your legal capacity is, whether or not you're considered competent to be able, that's why they always have to give you an attorney too, right? It's an infant is liable for the where does it say? He's liable for so much good. It says the general rule is that contracts of an infant are voidable by him, yet there are some contracts that are so clearly prejudicial that they are held to be not merely voidable, but absolutely void, right? Such as the contract of suretyship. But that's not how they got you. I mean, they are holding you as surety, but what they did right here is the mortgage, right? They mortgaged you, and that's how they can enforce this through equity as a infant. What do I mean? Why do I keep saying infant? Well, that's because, where did I pull it up at? I got it up here somewhere. Or maybe I'll just pull it up again. It's Title 1, Section 8 will tell you right away. Title 1, Section 8. Section 8, person. Okay, fine. It's going to make me search it all over again. Whatever. It's right here. So when you read this, in determining the meaning of any act of Congress, so that means all of their acts, they're telling you right here. This is called statutory construction, where they make their own definitions for their own pretend law, and they can do that because it's all make-believe in equity, in a trust, in a big trust arrangement, right? Big trust indenture. So they can write whatever rules and regulations they want for people under their administration. So when in determining the meaning of any act of Congress or of any ruling, regulation, or interpretation of the various administrative bureaus and agencies of the United States, the words person, so anytime you see the word person, anytime you see the word human being, anytime you see the word child, and anytime you see the word individual, shall include. Now, what include means, have you ever heard the term shall include but is not limited to, or includes but is not limited to, right?
Yep.
You have to put that extra part in there because the word include closes whatever comes after it. That's off. It closes it off, and it means only this. So there's an example I've heard is like if I construct a statute that said the word trees only means elms and oaks. Okay, or so the word trees includes elms and oaks, but I don't say including but not limited to. I just say includes elms and oaks. That's it. Then anytime in my statute that I'm writing that you see the word tree, ash tree is not included. Willow tree is not included. Nothing else outside of elk and oak and elm, right? I said elk. Oak and elm are included in my statute when I say tree. That's how they're tricky with this, called statutory construction, where they construct their own definitions using word magic like this, where you don't realize, because you use the word include all the time, that to include is to box something in, inclusive, right?
Right.
And you know what I mean?
Yeah,
So,
that's why that terminology has been so popular lately. Yeah.
right, you're containing it. You know what I mean? You're bringing it in.
Mm-hmm.
And so right here, they say anytime you see the word person, human being, child, and individual shall include every infant member, there's that word infant, member of the species Homo sapiens. So they're not calling you men, women, people, none of that. Species Homo sapiens, like you're an animal, who is born alive at any stage of development. At any stage of development. So what that's telling you is that you're a person, human being, child, and individual. If you're a 14th Amendment citizen and the acts of Congress apply to you, and they call you person, human being, child, or individual, it means you're an infant, even if you're 50, even if you're 70, at any stage of development.
Interesting.
Right?
Yeah.
You know, because infants cannot hold title. Infants automatically come under guardianship and administration, have their property regulated.
So that's why they put that caveat in there.
Yeah.
Right.
Yep. So, all right, back to this real quick. Just wanted to explain that for you guys. Let's go back to the claim now. Oops, gotta pull it up. All right, here it is.
Yeah, it seems nowadays the inclusion means exclusion, but
Right. Yeah, no kidding. The wokeism. Yeah.
yeah.
So that's why I say this of lawful age. So what I've done is I'm not decedent. I'm not missing, presumed dead. I'm not an infant. I'm a living soul manifest, meaning that my body is a product of my soul, which is huge because law always goes back to the spiritual. Yes, Valley Democrats. Yeah, okay. So Sergeant Frog Dog says a good example is the Ninth Amendment includes but not limited to. You have to put the but not limited to, otherwise you're boxing whatever you're defining into only meaning whatever you put after include. If you say includes but not limited to, that means you can add other things to be part of that definition at any time. So he says when I put anything on my documents that concerns my rights in any way, I always put includes but not limited to. Absolutely. Right. So let me make sure I didn't miss any other questions here. Kriprick says, Ryan, I gather they 100% count on most people knowing none of this. Yeah, absolutely. And they get pissed at. So I have a viewer, and shout out to his name's now Lawful Error, but it was All Souls. And All Souls was leaving comments on other people's videos, or he said videos came on talking about Roosevelt, the syphilitic cripple that turned our nation into a communist nation. Franklin Roosevelt. And he started, message him saying, hey, you want to learn more about this? Go check out Burn the Corporate Fiction. And he kept commenting. They deleted his channel. Said he was spamming people. Deleted his channel. Deleted the whole fucking thing. Yeah.
Speaking of that, did you turn off like comments on your videos and stuff?
I did not. No.
Wow. Okay. When I go to click on your videos or your shorts or anything, I can't even get into your comment section.
That's wild. Yeah. No.
Yeah.
Nobody.
Let me see if I can do. Let me see if it does it again. But go ahead. Continue.
Theo's had left some comments, but yeah, no, I know they're shadow banning the shit. X, I don't even get. Yeah, they probably mark mine. Like if you ever go down through comments and stuff and look at people's posts and it says probable spam, that's probably where you find my reels on X. Probable spam. They do not want people to know this stuff at all, dude. That's for sure. So
yeah, here, check this out. So you see, I got your short up, your last short.
hold on, let me see if I can pull you up real quick. There you go.
All right. See, I got your last short up.
Yeah.
And I go to click on comments. It just does nothing. See how it just kind of.
That's crazy, dude.
Yeah, and it does that for all of them. And then I don't even think I can get into your video comments either. Let me see here.
With the regular podcasts, like the streams.
Yeah. Oh wait, here I can. This one allows me to, but the other day it wasn't allowing me to put a comment on your videos either. But this one's. Let me see if it's. Maybe it depends on what you're talking about.
That's pretty crazy, man. So
let's see if I can do anything here.
All right. Let me.
Yeah, this is allowing me to. I don't know. It's not allowing me to do it on the short. So.
Yeah, that's weird, dude. Because Theo had commented on some of the shorts as well. So, All right, let's see here. Living Soul Manifest, one of the people of Michigan, an American, fully emancipated by express will and implication of will. Donor grant, that's all refuting the infancy, refuting the, so it goes donor, grantor, truster, testator, sole lawfully appointed absolute general, instituted rightful executor, and sole lawful general, forced testamentary unconditional heir, hereinafter referred to as claimant. Now remember, the reason I do that is now I don't have to write all that I'm of age and I'm one of the people in Michigan and all that. Now I just put claimant, and all through the rest of the document, when I put claimant, it means everything that just came before claimant, and it shortens up your document considerably, especially since this is a 31-page document I've drafted here. It took me a very long time. It was a labor of love. It's basically the distillation of everything that I have studied about how they do the system, and it reverse engineers exactly that. So, all right. So, anyways, so I said,
I guess one quick thing too on the shorts,
yep.
like I kind of did it wrong too, so I can't even comment. Like if I go down to hit the comment button down here, it won't allow me to put any kind of comment in your thing.
That doesn't surprise me, dude. I imagine YouTube is.
I'm pretty shadow banned too. Not that I have like a channel, a content channel or anything, but
no, you show up on everybody. I say you're on quite a few channels, and you do got some knowledge. So
yeah, they know what I say.
Yeah, that's true. All right, so it says hereinafter referred to as claimant of the Ryan Mason Wells estate, right? Notice I do that all caps because that's the estate that is in question, right? The one that they're claiming to administer, including all derivative spelling styles and variations thereof, as well as all trusts, expressed or implied, derived therefrom, hereinafter referred to as estate. So now when I say estate, it refers to any derivative spelling styles and any trusts, whether they're express or implied, that have been derived from the estate are now all included when I say estate, right? And that covers everything. And then it says whose will it is. And remember, everything all comes back to your will, right? That's the most important thing. Whose will it is to claim, execute, declare, ordain, and decree, establish, and appoint the following by action and deed of this lawful claim of title, blah, 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 right? Being in the form of a lawful action at law. That's why it's a declaration, right? It's a lawful claim and declaration. And thereby establishing a freehold in law, the appointment of trustees, the continued will and wish of claimant, and a list of executive orders under seal. Now, that's what makes this so vicious, right? Not only does it rebut all of their presumptions, every last single one of their presumptions, right? But it's also a performance contract. So starting with number one, you say, it is the will of claimant that all others immediately come forth and state a superior claim within 30 days, with lawful evidence bearing the seal of the House of Wells under oath, affirmation, and penalty of perjury, right, of the same, against the estate, or forever relinquish any hold, administration, use, right, jurisdiction, or other claim that may be against the estate. So you have 30 days. This is on the public record. I've served you with. You have 30 days. If this is wrong, then object to it. If this is wrong, object to it. If you have a superior claim and you can administer my estate and place me under jurisdiction, right? Then prove it. So it says the estate was registered with the corporate state of Michigan under United States corporate territorial jurisdiction without the consent of claimant, which is true. My mom had it registered it, well, applied and then it was registered. But his point is without the consent of claimant. I didn't give any consent. And the Virginia Bill of Rights, it says right there, written by Jefferson, it says that no one can deprive their posterity of their right to property. So my mom could not deprive me of the right to property. She could not sign me up into this. I would have to sign into this knowingly, right? The certificate of title to the estate is attached, being duly claimed and corrected by endorsement, seal of the House of Wells. So the claimant, the estate, and trust derived therefrom are separate entities entirely. Okay? So the estate is separate from me as a living man, and the trust derived from the estate are also separate from the estate and me, all separate persons, right? And I'm one of we the people, are separate entities in their entirety. claimant, being as stated in these actions, shall not in any way be joined with the others, they being ens legis, creatures of the law, right? Creatures of law, as such would violate the law of kind, right? Which is a doctrine of parity, right? Where non-living things cannot attain parity with living people. That's why they have to reduce you to property, right? So you said, oh, Roger's PC just locked up. Oh shit. Equity imputes on intent to fulfill an obligation. Yeah. All right. So let's see here. So yeah, okay. So law of kind and claimant is barred by principle, operation of common law, as well as the law of trust from assuming any liability for any charge which may have been heretofore, shall be at this time or at any future period, may be presented, presumed, assumed, or held against the estate or trust derived therefrom, without lawful evidence of a covenant bearing the seal of the House of Wells that would expressly state such condition. Okay, so it has to have my seal to where I agreed to it. So claimant is lawful age, sound mind, and by birthright has absolute authority over all matters regarding the estate. The derived beneficiary trust of the Social Security account numbered, which I deleted that the numbers obviously in there. I deleted that before the stream started because for obvious reasons. And all other trusts derived therefrom by redemption as sole lawful living heir the same. So you want to be the lawful living heir and you want to appoint yourself executor, because there cannot be an administrator and an executor at the same time. Those are both the same position, but one's appointed by will and one is appointed by the operation of law, because there is no will.
Maybe this is a stupid question, but what does a seal consist of, and does it have like limitations to it?
You can use a stamp. You can use
that's what I figured. But
I have an embosser. That's what I got, and it was very easy. I just ordered it from a place that makes corporate seals. Okay. There's no difference between a corporate seal and a house seal other than who holds it, right? Is it a corporation or a living man? And the house seal, right, it's got to be at 1.5 inches.
That's kind of what I was getting at.
Yep, it's got to be 1.5 inches, and it's got to be your unique design, and it can bear whatever Latin words you want or whatever, but it basically has to have your house name and seal on it. And then because originally it was candle and wax back with Lord Coke. And then it became, more lax. And now back when we had common law in the early 1900s and the mid 1900s, you would use a stamp or whatever they would allow. But I have an embosser, and so it's very important to have your seal. It's like, why do you think they seal everything?
Mm-hmm.
Right. So it's interesting when you say there's an aspect of law when it comes to seals. When anytime it's written where it says witness now fixed by our hands and seals, right?
Mm-hmm.
And you both sign it, right? But only you seal it, then the other person comes under your house. That document. If there's only one seal on the document, you come under the house of whoever seals on that document. So think about that when you have the courts got their seals all over it and you're signing court papers or whatever, right? That's why. All right, so claimant by birthright irrevocably appoints claimant as sole lawful absolute general instituted and rightful executor of the estate. Now there can be no administrator. Claimant now by executive order, because I'm now the executor, forgives, discharges, cancels, annuls, terminates, and disavows all juristic acts, charges, libels, liens, appropriations, indictments, orders, sentences, accusations, complaints, debts, policies, etc., right? And nunc pro tunc et usque ad finem temporis, which means from before till now and forever, basically. And hereby order all trustees named and appointed herein to govern themselves accordingly. Okay, so here's the interesting thing. Where is it at? I'm assuming any liability. Okay, so that's where we're getting at down here. So I basically go through all the difference. I said claimant by rights of blood and kinship, and common law with all United States persons being created by the 14th Amendment of the United States Constitution and are thereby subject to the Powers of Appointment Act of 1951, which is codified in Title 26 U.S.C., hereby levy and charge individuals, persons, and entities listed below as appointed trustees of the estate, as well as any trust derived therefrom. Now, this is where the performance contract comes in. This appointment shall be permanent and binding upon the following trustees, as well as any other who may presume to administer the estate without the express signed and sealed agreement of the paterfamilias, which is the male head of the house, or you can be a materfamilias if you're a woman, right? And paterfamilias of the House of Wells by the action stated in 1 subsection G below, and shall proceed under the condition of trustee until the following shall be performed. So what that is right there is that is an offer to contract. So basically is if you continue to administer my estate, you've now been put on notice that this estate's been claimed. Here's all the law regarding this estate and interacting with this estate. Now, if you continue to use this estate without my permission, right, you agree to be the trustee of my estate, and you must perform these following actions, right, or obligations. At first, all trustees shall give a full accounting of the estate for settlement, compile all records therefore, and transmit a certified copy of each record to claimant at their own expense to the domicile of claimant listed above. Shall perform a complete marshaling, collecting, livery of season, and delivery to claimant of all items regarding the estate as listed in the section below, right? And so here's a whole list of all the orders that they have to do. And then I say this. I say, where is it at? Each trustee shall agree to be billed by claimant. That allows me to give them a fee schedule, right? And they have to pay me within 30 days of me giving them a bill, true bill for the same, right? Shall agree that all appointed trustees shall remain trustee, each trustee being discharged only after that trustee shall have rendered performance of all orders stated herein. Upon performance of all orders stated herein, all trustees who have faithfully discharged the duties of that appointed office, et cetera, right? Failure by any appointees whose consent to appointment is lawfully tacit by continued administration of the estate. What that means is tacit by your actions. You didn't have to say, yes, I agree. You didn't have to sign anything. You kept doing this thing that automatically enters you into this contract. That's called tacit agreement to a performance contract. They get you with it all the time. When you go on different websites and stuff, they say, by continuing to use this website, you accept the use of cookies and the terms of use.
Yeah, TOS.
Right. Terms of service and all that. And now you don't have to say, I agree or any of that shit. You just keep using the website after that window popped up and boom, you're under that contract by tacit agreement. That's what we're doing here. Right.
Yeah.
So,
and they kind of back you into that with like your phone and everything, because it's like, if you don't agree to TOS, let's say you actually read the 8,000 page document or whatever. It's like, if you don't agree, then you can't use your phone anyway. They'll just lock you out.
right. And so here's the most crucial part of this is I tell them that each appointed trustee shall post a bond in the amount of $33 million, which is my funny way of, 33, right? 33 millions of dollars in gold certificates at the exchange rate of 42 and 2/9 dollar a fine troy ounce as stated in 31 USC section 5117B, or gold bullion of equivalent value, hereinafter referred to as bond. The bond must be delivered by bonded courier to claimant at the expense of the trustee as surety for performance in order to indemnify claimant against any breach, loss, misconduct, mismanagement, or malfeasance regarding the estate or trust that may be caused or committed by the trustee, right? Each appointed trustee shall agree to indemnify claimant in the same amount and of the same species as stated in the bond condition above. If the trustee fails to perform the order stated herein within 30 days of receiving notice of appointment, right? So let's see here. And right here, so if they don't want to post the bond, each appointed trustee shall agree that all real, personal, private, and estate property of the trustee shall be subject to actions of binding arbitration, liens, and collections up to but not exceeding the bond amount. In the event the trustee fails to post the bond or any other instance of non-performance occurs, the aforementioned property of the trustee shall be forfeited to claimant. So even if they don't want to go post the bond, they're still tacitly agreeing to put their property up as collateral and the equivalent value of $33 million, right? So now I know by now everybody's probably incredibly incredulous about like, no way this fucking works, right? But it does. So I'm going to show you something. And you guys can all do this at home yourself.
Well, that's the whole point, right? Too. I mean, to make you think you can't do it.
Right. Well, that is the point, right? So
Yeah.
we're going to go back here.
I mean, I'm pretty ignorant to a lot of this. That's why I come here to learn all this. But I know there's a lot more people like in your Jurist Society that know way more than I do. But yeah, they want you to think that you have no rights to any of these things, or you wouldn't be able to do it without us, or any of that type of thing.
Exactly. And you always need government permission to do anything.
Yeah.
You actually don't, because the next step after putting your claim on the record, making your seal, is to place all your property into a private express trust, which is a trust that is protected by the Constitution, that the Supreme Court has upheld over and over and over and over again as not being subject to statutes and codes of the state that would cause it to violate the performance of obligations of the contract, because that's Article 1, Section 10. You put it in that private express trust and say any property you put in there, you go, not to be used for commercial purposes under any circumstances whatsoever, right? So now when the road pirate tries to force you to put commercial advertising on the back of your car, also known as a license plate, you can say, no, this property cannot be registered in commerce. It's already registered to a private express trust. And the express conditions of that trust are to not ever use this property commercially. So I will not be putting a license plate on it or being required to have a license to use it because it's not commercial. And so you bypass all of their commercial stuff. It's Article 1, Section 10 says no state shall pass any law ex post facto impairing the performance of the obligations of contract. This is what the Rockefellers use. It's what all the wealthy Carnegies, it's what all the wealthy people use to protect their property and keep it out of the state's hands until they ended up taking over the state, right? Now that they are the state, we can use the same thing to keep it out of their grubby hands, right? So that's what we end up doing. That's what we learned in the Jurist Society. So, Mike, if you're still watching, that's what we're currently going through, is the private express trust situation. So, Colorado Secretary of State. So this is where you want to go, right? So you go to Colorado Secretary of State. You guys can all do the same thing if you want to verify and prove this to be the case for yourself. Go to Colorado Secretary of State. You click on it. You end up on this page. You go over here to Uniform Commercial Code on the right-hand side. Click that. You go down to search. You search debtor name.
She's pretty horrible, isn't she?
Oh, she's a wretched bitch.
Yeah.
She's about as bad as Whitmer.
Yeah,
that's what it is. And Benson. But look at this. So we do Walzell, put in, it's Walzl. First name's Daniel, middle name or middle initial is A, right? And then just go ahead and search that real quick. Oh, it says error, whatever. It did this the other day too. Or it's like not wanting to pull up the damn. You fucker. Hold on.
I thought maybe it's going to make you make an account like it does for everything else.
No, there it is. Okay, so there's his document number, right? So you click on the record number or document number, whatever. It's going to pull this up. So this same thing happened. This judge tried to administer this guy's estate. His name's Andrew, right? He tried to administer his estate. He had already filed his claim on the record. He served the judge with his claim, okay? And the judge continued to administer his estate. So he took him through common law process because, like I said at the beginning of this stream, that the government has the authority, the sovereign authority to hold court only because they borrow it from us. And we never divested ourselves of that ability. And the Magna Carta itself, which is the very first document in the Michigan compiled laws, if you look at it, they have to have the Magna Carta as the first because that is the document that created administrative law out of common law in the first place. And determining that that people under age will be administered until they come of age and all this. It's all from the Magna Carta. So Michigan puts the Magna Carta as their first jurisdictional authority in order to be able to have this big administrative fiefdom that they have right now. So my point in saying this is Magna Carta says no free man shall be deprived of his court. You can always hold court. And every court of record has a seal, which is another reason why you need your house seal. That's what Brett Nelson, this guy, did. He has his seal. He sealed the records of his court, right? The documents of his court. And they were binding. And when he defaulted that judge because he didn't take him seriously, he took the entire record of what was going on down to the Secretary of State and filed it with the Secretary of State, and they automatically put a common law lien against the judge's property immediately. And then he took the performance contract aspect of his claim, which I was just explaining to you guys about the bond and everything like that, and he took that to arbitration and got a default, like, because the judge didn't take him seriously, he didn't show up, and he got an arbitration award against the judge. And I'm going to show you exactly how much right here. Look at this.
Yeah, it's kind of Valley Parks earlier said something like that too. It was like a lien. So yeah.
Yep. $6,898,000 lien on all goods, chattels, tenements, and real estate of the tenements and real estate of the four debtors, which was a cop, a clerk, the judge, and someone else. I think the prosecutor, some DA. And he got all four of them. He got all four of them, and they owe collectively $6,898,000. So that judge immediately tried to move his house into his mom's name and everything. He tried to get the judge at the house out of his name. And as you see, the lien is still standing. This is still a standing lien, even though they definitely took revenge on Drew and hemmed him up for it. But they can do nothing about this because everything he did was lawfully right, by the books, by operation of both their law, right? Because he used UCC also as a performance contract. And by the common law, it is binding. And so this lien is still here. Look at this. It's all goods, chattels, tenements, and real estate, right? Brought forth as liened. And he is now their secured creditor. If that judge ever sells that house, he's got to pay Brett. If that judge doesn't, that judge cannot do anything with this house. So now let's go down here just so you know. And then look, yes, this is in our claim too. This is in the Jurist Society claim, is irrevocable durable special power of attorney coupled with interest, and they automatically agree to give you this by their tacit agreement through their action of continued administration so that you can sign for them. That's what this is. He signed the arbitration proceeding stuff. So first he signed over power of attorney to himself for them because the contract allows it, right? That's him right here. So he's taking power of attorney over Jessica Wagner, over where's the okay, was that the first one? Okay, that was the first one. So he took power of attorney over Jessica Wagner. He took power of attorney over where is it at here? Joshua Doherty. And then he signed it for himself, right? And then he could sign all of the arbitration documents on their behalf so that they had to submit to it. And it's all because that's all in the contract, the performance contract aspect of the claim. Right. So I'm proving this to you guys. This isn't some fucking charlatan bullshit that you can accept for value your securities and all. No, it works. This works. And when you serve it to them 9 times out of 10, it scares the shit out of them, especially if it's not a court, especially if it's like, a creditor or somebody fucking with you, right?
Yeah.
Mortgage company. So you send this to them because it's binding, because it works, and they read it and they recognize it right off the bat for what it is. Like, holy shit, okay, this guy not only is claimed as estate and is not under administration, but has also turned the table on us with the performance contract, saying that if we continue to administer it, then we by tacit agreement become a trustee to the estate, subject to a frickin' $33 million bond or a lien of our personal property in the same amount if we fail to post the bond. That's what happens, right? So, or they could give you a proper accounting and then you actually give them a dividend of your estate when they give you a proper accounting and livery of the property of the estate. You could offer that in there as kind of a carrot and to make it a lawful offer of contract. So there's some consideration being offered. Hey, I'll give you 10% of the estate to be split up with however many trustees help me settle the estate. Right?
Yeah, so that'd be like a board of trustees for you. Yeah.
Right.
For yourself.
Exactly. And then so you're also offering them valuable consideration in exchange. So it's not just a one-sided contract, which would void it. So you have to have two sides to the contract. But they're never going to settle your estate for you. And they're never going to give away all those records and stuff like that. So usually what they have done and what they do is they just zero everything out and leave you the fuck alone because they don't want to mess with it, which is all we really want in the Jurist Society. We're not looking to actually sue these people or place liens on their property like Brett did, but we will if we have to. But that's not what we're out to do. We're out to just be left the fuck alone. That's all we want. Just leave us alone. Let us live our lives. Let us have our property and stop pillaging us. That's it. Right. And if you do not do that, then look, this is right here. Now, his is much different than mine in that it's just written a lot differently. I didn't like the way that this one was written, so I rewrote the whole thing. I added some things, a lot of things actually, and I took even more things out because there's some sections right here where it's like this. No, this isn't the section. I'm trying to turn my head sideways so I can read it. So he's got his own list of trustees, standing orders, blah, blah, blah. Yeah, this type of shit right here would dispute, petition, audit, tag, extension, basis, remittance, entitlement, ticket, compensated, where he just goes through and lists all the shit, recording, collection. Just so unnecessary. You can make it so much simpler, short, and concise. You know what I mean? Oh,
Yeah.
we got Faye. What's going on, Faye? How you doing?
Hey, Ryan, good. Thank you. And thanks for having this. I had a question for you, though, because as I'm doing as I'm doing my claim, that part kind of confused me, the power of attorney. Like if we're their adversary or whatever you call it, how are we able to do that? Like, isn't that like saying, even though we're going to oppose each other, I'm going to represent you?
So right there, you don't, you're not their adversary when you offer that contract. You're not being their adversary. You're putting them on notice. This estate. Hold on, let's not explain.
Oh, sorry.
Yep, so you're put on notice. This estate's been claimed, and this is also a performance contract. If you continue to administer the estate, then I'm going to presume, right? You're going to agree to be the trustee of the estate and give me a full and proper accounting and a livery of my property, right? And livery of my property. So all that is there's nothing adversarial about that at all. You're giving them the option. They don't have to continue to administer your property. They could leave you alone, be like, oh shit, I thought this was still being this was still under administration. Just leave it alone, right? They could absolutely do that. But if they do not, then what they are doing, and what you can presume that they have done, is they've read the entire thing and that they are okay with giving you a proper accounting and putting up a bond and all of that, right? That's how you have to look at it, because first of all, you don't want to be adversarial in court in general, because that places you in dishonor. What you always want to do is try to come to an agreement, come to a meeting of the minds. And so you have to look at it like that when you're offering that, or when you present them with this, is that you're merely informing them of the standing of the estate and the situation involved with the estate, like what comes with messing with the estate. And then if they continue to do it, you can presume that they have agreed to this and that is what they want to do. And then if they maladminister the estate, which they're going to do, but you're supposed to pretend like they're not going to, right? Like this is a good faith contract, but they maladminister the estate, and that is part of the repercussions. As part of protecting your estate, is that, look, if you maladminister my estate, then you're subject to arbitration. And if you don't want to cooperate, I have power of attorney over you to sign for you to force you to cooperate, because I'm protecting my estate. The whole thing hinges on the fact that they never had to enter this contract in the first place. That's what makes it valid. You didn't automatically just be like, gotcha, bitch. That's not how it works, right? Right? No. You're like, hey, look, hey, I get it. Honest mistake. You're administering an estate that's not under administration. It's a crime. It's executor dis on tort, but let's just presume it's an honest mistake. Here, I'm presenting you with this that's on the public record. And then if they continue afterwards, they are being malicious. They are committing malfeasance, right? If they continue to do what they were doing and not do what the contract says to do. So all you're doing is exercising your lawful right according to the contract to protect your estate and to get justice and compensation for the injury done to you.
But how can you enter into arbitration with someone if you're their attorney?
You're not. No. So
I'm misunderstanding.
It's not the same as. So the word attorney just means to take one person, to transfer homage and service from one person to another. That's actually what the word attorn means in the first place. And so the term power of attorney is not the same as being an attorney. Anybody who's not an attorney can have power of attorney over some aspects. And all that means is that they're giving you the power to transfer their homage and service or their word, and if you read the document, it's only regarding the estate. It's only regarding the estate.
Oh, okay. Okay. I thought it was everything.
No, you gotta, if you read it carefully, that's how I worded it, is it's only regarding the estate.
Mm-hmm.
It's okay. A very, very fair power of attorney. It's only as far as it concerns, the estate or any dispute arising from the estate or any trust derived therefrom, right? So that's it. That's all you're getting. So he was only, like, for instance here, he was only able to sign power of attorney for them for the arbitration for the estate. Not like he could just go over and sign over the title of their house to him or something, you know what I mean? Or like sell it. None of that. No, it's just as far as it concerns the estate and any dispute arising from, a trust or anything involving the estate.
Okay. Now, the other thing I was going to ask, though, is just because of the volume of it, how do you deliver it to all these different agencies like that? Is it just you got to bite the bullet and print it out, or
wait, what? Oh, the
as
power
far
of
as
attorney?
delivering the claim to all of these places?
Oh yeah, hell yeah, you got to print it out, but you do not have to. I mean, here's the thing, because it's on the public record, you don't have to do certified copies. It's already on the record. If they don't believe you, so certification is to validate something, right? To make, like, hey, this is actually authentic. Well, the thing with the claim is anybody can verify it's authentic. Right now, you could look up my claim on the Muskegon County Public Record. You could look it up right now. So I can send them just a regular copy of my claim, and it doesn't have to be certified, because if they don't believe me that it's on the public record, they can look at the public record number, go to the county website and be like, oh shit, it is on there. Okay, great. He's not making it up. It doesn't have to be certified. So you'll save a lot of money that way, because they want to charge, like, at least here, they want to charge like $40 a copy. And I was like, you guys are smoking crack.
Yeah, certification adds up.
Yeah.
They must make a fortune doing that stuff.
Well, yeah, the funny thing is I looked up the oldest statutes in Michigan, right? When we first established the county register and the county clerk and all that stuff, and there's not supposed to be any fees. The fees are supposed to be paid for out of the county treasury. That's right. That's collected, that's accrued by proper taxes, not property tax, income tax, and all the improper unconstitutional taxes. But the proper tax system, and they would pay for it right out of the treasury, because it's a public utility. They're public servants. We pay for everything they do already with taxes. Why are you going to charge me to do something when you already are paid by me? And that's how it should be. And that's how it was. But I wasn't going to argue with them. I was just glad that they filed the shit without giving me a hard time, because I was totally prepared for a fight. And I'll tell you what happened when I went down there to file the claim. I had my daughter with me, and we were standing there, and I go, yeah, I need to file this on the public record. And she grabs it. She goes, okay, starts reading through it, right? She goes, I'll be right back. Goes back, takes it back to the county register or registrar or whatever you call him. And he's sitting back there, and he's back there for about 15, 20 minutes just reading through the whole fucking thing. And then she comes back. I'm like, oh, dude, this guy's going to give me a hard time. Nope. She came back up and said, okay, do you want this returned to you immediately, or would you like it mailed to you? I said, you can mail it to me. And that was it. And then you could tell that she wasn't happy about it at all, but she filed that and my publication of the House seal, and boom, it was. Yep. So, Valley, the injury I was talking about is the maladministration of the estate. So that's an injury. It's so at common law, it's called executor disuntort, which means executor of his own wrong, right? And it's what happens when somebody attempts to be the executor administrator of an estate that is not under administration or in a trust, right? That they don't have the right to do it. And that has historically been a problem. Now it's commonplace. It's all they're doing in this country. is administering decedent estates and bringing in the infant trustee as chattel property of the estate. See, people think they're talking that. That's why people think if you're arguing your case in the court, like if you're in the trial aspect of their equity court, you've already lost because you're in rem. You're there as property or quasi rem, but you're there as property. That's the only way they can even deal with you as legal fiction, as artificial constructs of the mind. They have to place you in rem. That's what the 14th Amendment citizen is, chattel property. And so when you're in there, they're not dealing with you. They're dealing with the estate, with the matter of the trust, right? And they're only dealing with you as property of the trust, the property that was held responsible for performing the obligations of the trust. So they're dealing with things. That's why we say I come before the court having been found to be living, because first of all, I'm one of we the people. We come before the court and I'm living. I'm not property. I'm not a thing. And this has long been upheld. English common law, chattel property is property. Like servants, slaves, they're property. They're not people. That's how the law looks at them. There's this case I was telling you guys last night. There was this case where there was a slave ship and they ran out of fresh water and stuff like that, and they didn't make it to port, so they started hucking slaves overboard. And there came the matter to be adjudicated of who would pay for the slaves that were thrown overboard. And they were talking about, well, because they're people and this and that. And it's like, oh, no, they're not people. They're chattel property. And so what they said was that this is not a case of throwing living people overboard. This is a case of disposing of goods, basically, of throwing goods overboard. And that's how they continued with the case of looking at it like you threw away somebody else's property. Yeah, it's wild, but that's what that's why they needed to create that 14th Amendment class of citizenship, so they make you property.
Okay.
Yeah, so they make you a chattel. You're indentured automatically when you read the 14th Amendment, and it tells you right here. Wait, do I have it pulled up?
I think if you hit Control Alt left arrow, it'll turn it 90 degrees to the left. I don't know if you got to highlight it, but
what, this here?
Yeah, I think it'll turn your screen. Control Alt left arrow. Usually it'll turn your screen 90 degrees to the left.
Alt. I'll try it.
Maybe not. Negative. I don't know if you got to highlight it.
Well, it's just the way that this was scanned into their stuff. You can actually just, you guys can get this if you guys like this claim. This claim, in my opinion, I spent probably 2 months reworking this whole claim to make it to what I have now, 2 or 3 months reworking this whole claim. But what I was going to show you is the 14th Amendment, why it's chattel property. It's so important to understand, but I don't know if I had it pulled up. So what I'm going to do is just pull it up again, or go to this Constitution website, right? So we'll go to, okay, that's just that. There's the 14th Amendment. Let's do. All right, so it says right here, all persons born or naturalized in the United States and subject, right there, that right there is we the people are not ever subject to the subject means like a subject of a sovereign, right? And it says in Chisholm v. Georgia that the government is subject to us, we the people. So what they did was they created, first of all, you notice that it doesn't say people, it says persons. Right. And persons include, right, here's the definition of person. Definition of person, for the purposes of this part, the term purpose means any individual or association, organization, public or private, which is organized, permanently established, resident, or registered to do business in the United States or any foreign country.
Yeah, that's like when you get pulled over and the cops say, is it on your persons or whatever, right?
Right. So this is what a person can be: a partnership, corporation, company, government or any department, trade association, charitable or fraternal organization, right? The term United States person, this is very interesting. This part applies to United States persons. For purposes of this part, the term United States person means any person who is a United States resident or national, including individuals, right? So that way they can not only be talking about companies and corporations and trusts and all that, but they're also talking about individuals, domestic concerns, and controlled, in fact, foreign subsidiaries, which would be we the people, I would imagine, but affiliates or other permanent foreign establishments of domestic concerns. The government of the United States, Department of Agency, the government of any state. So these are all United States persons. Look at that. I just told you the government of any state of the United States is a United States person, just going exactly against all of the jurisprudence of the 1800s, like all the way to the end of the 1800s, where they make distinct, a clear distinction between United States citizens and state citizens. Right, all the time. Like even where Maryland and the Hendricks v. Maryland was trying to charge the United States citizens, or trying to require them to have a license just to drive out of the District of Columbia through Maryland. They were like, you got to have a license. It's interstate commerce, because they weren't one of we the people. This is public chattel. So they could start imposing stuff like that on them. That's Hendrick v. Maryland. You can read that whole case. It's about the difference between the people of the states and the people of the United States. We've got Chisholm v. not Chisholm v. Georgia, McDonald v. State, which is right here, that tells you, and this is Indiana Supreme Court, and it tells you that though he was not a citizen of the United States, he was a citizen and voter of the state. Under Section 2 of Article 2 of our state constitution, one may be a citizen of a state and yet not a citizen of the United States. And it's important that you are not a citizen of the United States, because citizens of the United States are subjects, okay, to the jurisdiction thereof, are citizens of the United States and the state wherein they reside. So that was to establish the initial dual citizenship, right? But you still had to naturalize with the United States, or you had to be born in the District of Columbia. And that's what this court case is about, is this guy had moved from Germany, okay, to Indiana, and he naturalized with Indiana, but he never naturalized with the United States. And that's what they were talking about in this case. It even tells you later on, and I don't remember exactly where, but it tells you that's the case. He naturalized with the state. He didn't naturalize with the United States, right? So when they use this terminology here, born or naturalized in the United States, they're talking about the District of Columbia, federal corporation. You naturalize with the United States, then you become a federal citizen, and then you become subject to the jurisdiction thereof, right? And right here is the benefit that you get for coming under their administration as an infant ward. And they offer you privileges and immunities. And so you have to really look at why this would appeal to anybody. And the people that it appealed to were the newly freed slaves, who had no rights and no constitutional, were just sitting ducks in the water because they had all their needs taken care of for them for generation after generation, until all of a sudden said, hey, you're free now, right? And then they're like, well, shit, right? Mm-hmm. You know, not that they wanted to be a slave, but they had no trade, they had no property to speak of, they had nothing to sustain themselves, right? And so this was offered to them. Hey, we'll protect you. We'll make sure nobody takes advantage of you. We'll give you civil rights, which are actually privileges and immunities. But in order for us to do that, anything that the government offers protection of, it must have an interest in. That's the whole thing about registering your car. That started as the Theft Prevention Act, right? And it was voluntary. You're like, hey, you could register your car with us, and if it gets stolen, we'll be able to help you find it. Right? Well, why would they help you find it? Because now it's their property. They have an interest in it. It's the same thing with offering privileges and immunities. In order for the federal corporation, who is foreign to the people of the states, who has nothing to do with the people of the states, could never dream of enforcing anything against the people of the states. Okay. For them to be able to enforce something against the states regarding the people, you have to come under them as like a mafia, like a protection racket. You have to come
that's
under.
what Sarah was saying. Mafia.
Yeah, it's like a mafia. Yeah, exactly. Mafia as fuck. That's absolutely right, Sarah. Yeah, you couldn't even be more accurate if you wanted to. That's exactly what the hell it is. It's a mafia.
Yeah, and I've heard talk, well, I'm sure everybody has it, Trump was talking about federalizing DC recently because of crime or whatever, under the guise of crime, but yeah.
Exactly. So, yeah, and then this here, you've got the, what's the other piece of shit court case? So then it wasn't long after they did the 14th Amendment. I know I have it right here. Santa Clara County versus Southern Pacific Railroad. This is where they were able to, just because of this asshole's little opinion here, this is what they have construed to mean the whole time, to allow corporations to be persons. Just this is it right here. So anybody who says, well, we know corporations are persons, It's Santa Clara County against Southern versus Southern Pacific Railroad has already established that. This is what established it. Watch. The court does not wish to hear an argument on the question whether the provision in the 14th Amendment to the Constitution, which forbids a state to deny to any person within its jurisdiction the equal protection of the laws, applies to these corporations. We are all of the opinion that it does. That's it. And now all of a sudden, boom, corporations are 14th Amendment citizens. But they had to do that to federalize everything, to federalize all the businesses, to federalize all the corporations. Because before, corporations were made by the power of the state through the statutory authority of the state alone, and only held its allegiance to that state and existed at the mercy of that state because it was a corporation made from the power of that state. So when they did this stupid stuff here, they were able to now federalize all the corporations, which put the United States as like the head corporate oligarch and king and or chief of the fiefdom, basically. So but that right there, so think about this too. So with the 14th Amendment, which I've already proven a million times, Blackstone or Black's Law Dictionary 4th edition tells you right in it that, well, yeah, okay, here you go, person. The word term may include artificial beings as corporations, right? So, and then also they say a person, a man considered according to the rank he holds in society. So it's still not one of we the people. And that's different from, so like a baron would be a person, right? A knight would be a person. That's not the man who holds that rank, but that's just referring to the rank. It's the same with the United States citizenship. It's just referring to the trust, to the rank. And so, but the 14th Amendment tells you, whoops, without a doubt, and I usually already have it open, but it won't take long to get to it. So just up a little bit. Okay, it's going to be right down here. So FO, blah, blah, blah. Come on. Whoops. Went a little too far. Stop it. Damn. Bear with me. Like I said, I usually have this pulled up. There's a lot of FOR words in the law, apparently. So 14th Amendment. And so you guys can see this. I'm going to zoom in real nice and close so everybody can see this. It became part of the organic law July 28, 1868, and its importance entitles it to special mention. It creates, or at least recognizes for the first time, a citizenship of the United States as distinct from that of the states, right? So why would they want to do that? Why would they want to do that? Because how could they, whoops, hold on, wait till it comes back up. All right. How could they do this? How could they tell the states what they can or cannot deprive anybody of when you have other holdings that say that the Constitution, which case was that? Ex parte Knowles, Maxwell v. Dow. Is it this one? Yeah. Okay, look, the Constitution was ordained and established by the people of the United States for themselves, right? So look, hold on, let's actually look at this. And this is from 1832. So this is before the 14th Amendment, okay? And this is how it originally was. It says the provision in the 5th Amendment to the Constitution of the United States declaring that private property shall not be taken for public use without just compensation is intended solely as a limitation on the exercise of power by the government of the United States and is not applicable to the legislation of the states. So saying the Constitution is not applicable to the states. It doesn't have anything to do with the states other than what it restricts the states from doing, like Article 1, Section 10, where states cannot enter into treaties or confederations or emit bills of credit or coin money or none of that. It all belongs to the federal government. But other than that, unless it's specifically something prohibiting the states from doing something, the Constitution only applies to the federal government. That's it. And it says the Constitution was ordained and established by the people of the United States for themselves. Who is that? It's the people of the United States, the company, the corporation, for themselves and for the people in their little 10 square mile territory. That's it. For their own governments and not for the government of individual states. Yeah, read that again. Not for the government of individual states. So what the hell is this? Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. That is federal overreach right there, because the whole point is the states have their own constitutions because the people choose the law under which they are to live. And it has to be in accordance with common law. Has to.
Not the pursuit of happiness.
Well, that's, yeah, but
I was just kidding.
but that's a very vague generality. It's stupid.
Yeah.
You want to read the real Bill of Rights. The real Bill of Rights is the Virginia Bill of Rights, which you can find on Hathi Trust. And the real Bill of Rights tells you that everyone has the right to life, liberty, the ability to acquire, possess, and protect property, right? The right to have your family and the right to contract. And then no individual can deprive their posterity of the right to property, which means your mom signing your birth certificate doesn't matter. So the one provision of the federal constitution that affects the people of the states is the Article 4, Section 2, which tells you that what is available, the privileges and immunities of the people of one state or the citizens of one state are available to the people of all states, right? So that affects in a uniform way. That's what creates the doctrine of equal footing, right? And that's what makes everything common law. It's supposed to be in concordance with common law. And because this entire, it even says in talking about establishing citizenship, which I believe is this ex parte nulls, tells you right here, the power to naturalize is made a judicial power by act of Congress, federal Congress. But Congress cannot confer any judicial power upon a state court. The provision of the Constitution of the United States, which gives Congress the power to establish and rule uniform rule of naturalization, is construed to mean that rule, when established, shall be executed by the states. So Congress just gets to make the guidelines of how states will naturalize people into state citizenship, but the choice and the actual execution of who and how to make somebody a citizen or when to make somebody a citizen is up to the states themselves. That's why Andrew Johnson vetoed both the Civil Rights Act and the 14th Amendment. He says you're creating a federal class of citizenship and taking away the state's authority. The state has the sole authority to determine citizenship, to determine who becomes a citizen and who doesn't. Congress has no ability. This was the balance on that, was Congress can make the rules for the process of naturalizing somebody, but Congress can't tell the states who to naturalize, and Congress cannot naturalize themselves, period. And so he tells you right here, under the Act of Congress of 1802, every court of record in any individual state having common law jurisdiction and a seal, which is what we've been talking about the whole time, and clerk or protonotary shall be considered as a district court within the meaning of this act, because those were people, that's where you went to go get naturalized, within a state. And it had to be a common law court of record. He tells you right down here at the bottom, he says, all other courts of this state being courts of inferior and limited power, because all statutory courts, all administrative courts, every other type of court that's not a common law court is called an inferior court. The only actual court of actual law where you can affect citizenship and all that stuff, or where actual serious crimes are tried or any of that, has to be common law. It has to be. That's why this whole thing that they have set up right now is a big pretend. It's a big game of pretend. It's all fake, made up, imaginary corporate bylaws and rules and regulations that are not law, require the color of law for them to apply to you. But because you do not know any better, they just presume you to be under all these layers of contract and presumption, right? That makes this color of law, these corporate bylaws, apply to the regulation of your property. That's what I try to say all the time. Man cannot make law, period. Blackstone upholds it. Every jurist worth his salt knows that man cannot make law. That's why these evil beast governments have to circumvent that fact and try to usurp God's authority by reducing people to property. They reduce people to property because the only thing man can do is regulate matter, which is unfree, has no will of its own, because you can't affect anyone's free will. So they can regulate property and commerce. And so what they do is they create these situations of like administration through the Magna Carta presumption. Oh, you're not of age, you're not of sound mind, you're a pauper, you require help. And they turn you into property as a trustee and chattel of your own estate. And then they can regulate you and all of the property as property in rem. It's the only place they can enforce their imaginary rules, in rem. That's it. That's why all admiralties in rem. It's all imaginary shit to do with commerce and goods and international trade in rem. The sailors on the ship, they're property of the ship in rem. Everything's in rem, because in rem means dealing with just property, not living beings, just property. All right, so let me see if we have any questions on that real quick. So he tells you right here, he says, all courts of this state, and then I'll check for questions. All courts of this state being courts of inferior and limited powers, and although some are courts of record, yet having only statutory and not common law jurisdiction, they have no power to grant naturalization, at any attempt of the kind by them would be carrara non judice and void, right? So he's telling you two things. One, only courts of record can naturalize people, and that has to be within the state, right? That's the only court that can confer citizenship. And secondly, he's telling you that anything that's not a common law court of record is an inferior court. Now, all we have is Article 1 inferior courts. That's it. That's all we have.
Ryan.
Yeah.
I'm sorry, what is this you're reading to us?
Oh, we got Roger backstage. This is Ex parte Knowles from 1854. Ex parte means basically single party. They didn't actually have a court case. This guy filed this thing, and then the judge gave his opinion on it. Boom, right?
Is this in the mega folder?
No, this is on case law, or this is on the Case Law Access Project, which is Harvard Law School. They have like every court case that's ever been adjudicated in the Republic, even before it was a republic and it was still colonies. It goes all the way back to the early 1700s, all the way up till today. They have like everything. It's a great resource. I can put it in the private chat if you want.
Yeah, I was about to throw it in there.
Thank you. How do you look up cases, like if you just want to see how across the country they have ruled on just whatever you're looking into doing, but you only know the subject matter? How do you look up the cases?
So look, they're not ever going to have ruled on they're not ever going to rule on what we're doing, because they cannot. That's the whole point, is that this, like, because they've taken away courts of law. So how do I put this? Before, this wasn't an issue until the bankruptcy, and they tricked everyone. See, people have been asleep for decades and decades and did not know this had taken place. And for whatever reason, people have been waking up the last 15, 20 years and have been uncovering all this fuckery that was done in the law. And so during that time, while everybody was sleeping, because you had the Civil War, and then you had the Reconstruction era, and then you had a banking crisis, and then you had another banking crisis, and the Federal Reserve was instituted. Then you had the World War I, the Spanish flu pandemic. Then you had the Great Depression, World War II. And so they kept rocking people with trauma, left hook, right hook, left hook, right hook, left hook, and just fucking the country up and the school up and everything, until finally, when things settled back down to normal after that tumultuous 50, 60-year period, several generations had passed, and the people were just glad to have things going back to normal, and nobody gave a shit about it. And plus, they made life really comfortable with that artificial womb I talk about, right? So my point in saying this is, back when there were courts of law prior to 1933, this was never a case. Well, there is one case, actually. There is one case I can think of. And it was right before the Great Depression, and this is 1922, and it's an equity case, but this is the equity with common law, right? Not Roman civil law equity. And so let's see here. So they tell you right here. So basically, this lady, and I've shown you guys this before, her name's Edna Long, is distrained by this IRS tax agent who thought that the tax code applied to her, but she wasn't a federal citizen. She wasn't a taxpayer. She's a non-taxpayer. And so she sued him and won. And so you can use this case, but this is about the only case I've ever come across, because after they got rid of the courts of law and dealing with whether or not somebody is or is not a United States citizen, they barred access to common law, unified all processes. So there was no such thing as at-law action anymore. There's just inequity in rem. Basically, all of it is a mixture of civil, admiralty, equity law, right? Which is all really equity, in my opinion. Anyways, it's what equity. But anyway, so admiralty is a little different, but it is. It's all basically, it's man-made shit. It's not actual law. Took away all the courts of law. And so now if you are adjudicating your case at trial in these courts of equity, the judge can do whatever he wants, Faye, because that's the whole thing about a court of equity. That's the thing. Look at this. So you got this Bouvier, and then I'll get back to this Long v. Rasmussen thing. But you look right here, and so, or wait, no, where did I pull it up? I pull it up over here. My bad. Okay, the discretion. So when it is said that something is left to the discretion of a judge, it signifies that he ought to decide according to the rules of equity and the nature of circumstances. The discretion of a judge is said to be the law of tyrants. It is always unknown. It is different in different men. It is casual, and it depends on the constitution, temper, and passion. In the best, it is oftentimes capriciousness. In the worst, it is every vice, folly, and passion to which human nature is liable. Okay, that's a court of equity, right? It tells you discretion is according to the rules of equity. That's a court of equity. We got Blackstone over here, right? Blackstone says, and on the other hand, the liberty of considering all cases in an equitable light must not be indulged too far, lest thereby we destroy all law, because you're basically making the judge God, and leave the decision of every question entirely in the breast of a judge. Okay? And then he says, and law without equity, though hard and disagreeable, because it's just black and white, doesn't deal with pretend, doesn't care about mitigating circumstances. Did you hurt somebody? Did you violate somebody's free will? Says it's much more desirable for the public good than equity without law, which would make every judge a legislator, I say God, and introduce most infinite confusion, as there would then be almost as many different rules of action laid down in our courts as there are differences of capacity and sentiment in the human mind. Now, if that's not bad enough, so you see William Blackstone tells you the danger of equity, right? And then, so what do we have over here? We have,
That's really well written.
Well, they had a way with words back then. They weren't dumbed down with fluoride and everything else, but they were much more educated and knew the law. You know, they were intellectual, knew the law. So right here, you've got this law from the International Law Journal. What's it called? It's called Northwestern Journal of International Law and Business, spring of 1983, Equity and Admiralty, a turbulent path to manifest destiny. And right here, they tell you, effective in 1966, the federal rules of civil procedure were amended to effect the unification of civil and admiralty procedure, because they were bringing the international commerce of the sea inland, and that's what UCC ultimately ended up. That's what it is. It's a blend of civil and admiralty procedure, where everything is international trade and the administration of property combined, right? And it says, with this amendment, the advisory committee intended that just as in 1938, now remember everything we just learned about equity, right? The difference between equity and law. Rules abolished the discretion between actions at law and suits in equity. How could you do that? Didn't Blackstone just warn against that? Didn't he say that it would make basically the judge God, right? Yeah, isn't that right? Well, of course, that's why they did it, because the Bar Association is the one who, the entity that is primarily enacting this entire scheme on behalf of Satan himself. That is what's happening right now. Okay? The bar wants to be God. Satan wants to usurp God's authority. This is what they're doing with their digital system. That is the whole point. They're depriving us of the lawful jurisdiction. Okay? They're depriving God of his lawful jurisdiction by turning everyone into property and then placing them under administration, where law doesn't apply to you anymore. In fact, the rules of equity can compel you to violate law. Right? That's satanic. That's an inversion. That's the difference between law and equity. Okay. Equity deals with pretend. Trusts always have to be adjudicated in equity. So how did they lock you into equity? This right here. How did they see? They can't ever get rid of law. All right. They can't ever get rid of law. What they have to do is they have to bar your access to it. So right here, where it shows you that they mortgaged your estate in 1933, the money will be worth 100 cents on the dollar because it's backed by the credit of the nation right here, right? It will represent a mortgage on all the homes and other property of all the people in the nation. Well, the only way they could do this was by creating a trust to attach all of your property to. That's what Social Security is. So 2 years after this happened, they passed the Social Security Act, created the Social Security Trust to link all your property so it can be used as collateral for the mortgage. What did that do? It made you the trustee of your own estate, which you already were as a 14th Amendment citizen anyway, but at least your property wasn't mortgaged. But now you're the trustee of an estate that has been mortgaged. Okay, you already only had equitable rights in your property, but now you have you're locked into equitable rights to everything because they took away your money. You cannot buy anything. Okay, you can only exchange debt. You can only what's called purchase, which is when you use negotiable instruments to acquire property, and those negotiable instruments are contracts that have strings attached to them, and they transfer those strings to whatever property is purchased. And it's all done in trust, and it all has to be adjudicated in equity. And in equity, the judge is God. So that's why I'm saying you don't want to necessarily just go looking for court cases of people trying to be sovereign, because if they're arguing, they're standing in court, they lose. If they do like Brett Nelson did, which I showed you guys, they get the judge for $6,800,000 and lock up all of his property because he didn't go through that jurisdiction of equity. He took him through an at-law process and then arbitration to enforce his contract, and he railroaded that judge. So that's how you do it. Do you understand what I'm saying? I know it's complicated, but hopefully that helped you. Benji Boodles, thank you very much for the super chat, brother. This is he says, thank you for your channel. It's epic MAGA file. Right on, dude. I appreciate it, man. Thank you. So yeah, this so apparently Roger, we lost him. I don't really know.
So Ryan,
go ahead. No, that's fine.
I'm sorry. So I came in late. I apologize. So that guy won against the judge by taking him through a common law action.
So look, so yes, I understand where your confusion is. This right here, this is a lien on the judge, the prosecutor, the cop, and the court clerk, all their property for $6,800,000, and it's because he did not go to trial under the judge's jurisdiction. He used the sovereign jurisdiction of common law, took him through at-law process, which is something that we are going through. We're going to go through in the Jurist Society. I've gone through it with you guys a little bit, but the first thing you have to do is claim your estate, which is where some of you are still at, and then place the property into a private express trust. But the at-law process is simple. You just draw up a declaration, serve them with it. You can hold your own court. Once you're one of we the people and you have a seal, you can hold your own court. That's exactly what Andrew did. The judge disregarded what he was doing. Okay, he said mega. Okay, mega file. Got you. I appreciate it. Yeah, the mega file. Got you. I'm going to add more to it actually this weekend also. Took him through the at-law process, which all of those templates are in the Jurist Society folder, by the way, declarations and notices of liability and everything else that you need to take someone through process. And I'll explain exactly how to do it. You serve them, right? And once you serve them, they have the opportunity to respond. If they do not respond, you file show causes, right? If they do respond or whatever they're responding with, and you just use their courtroom as your at-law. So the concept behind it is this. At law, there is no judge. The people are sovereign at law. So one sovereign has to take another sovereign to court over a wrong. Now, whoever files the at-law suit is the sovereign, and the person defending themselves has a right to be defended by a jury, which then becomes the superior sovereign in the courtroom. The magistrate or justice of the peace is just a paper pusher. That's it. That's all the magistrate. If you look up the definition of the word charge in Bouvier's Law Dictionary, it tells you that that's just where the judge or the magistrate merely stops the proceeding and points out how what was said applies to law, and then shuts up and sits there and lets it continue because he has no tribunal authority. He has no ability to determine the facts or the law. That's all up to the jury. Okay, so
How did he find the jury though? The sovereign.
that's the whole thing, is that the judge didn't take him seriously, so he didn't ask for a jury or anything. He just kept ignoring his filings. And so Drew just took him through the whole process and then gave him a default judgment. And then took that default down to the Secretary of State and filed it. And because it was a proper at-law process and he crossed his T's and dotted his I's, the Secretary of State had no choice but to put a common law lien on the judge's property. Boom. And then once he had the common law lien on the judge's property, he then took the performance contract aspect of the claim and took that to arbitration. And then the judge, of course, didn't take him seriously, ignored it. And then he got an arbitration award and took that down to the Secretary of State and placed that lien on all of the judge's property. And so now it's awesome, right? So the judge is sitting there with a $6,898,000 lien on all of his goods, chattels, lands, tenements, and real estate. So, and there's nothing he can do about it. Still, this is current. I just looked this up. It's still there. There's nothing they can do about it. It was all done right. And they cannot take this lien off. There's nothing they can do about it.
Yeah, that's why he brought up that Latin term, what was it, coram non judice? That was similar to that.
Right. And so there's absolutely nothing they can do about it. Even as pissed as they are, even if as they retaliate against him and they try to say that what he's doing was wrong and he's doing paper terrorism and all, well, the lien's still here, isn't it? So obviously it wasn't wrong. And that's the point, is it's not, because it's by operation of law that is much older than even this republic is in general. It's much older. It comes before this country. It comes before any government. This is the original law. Right? So you're under God's law, common law, right? Unless you enter to a contract, then that contract supersedes your normal common law rights until you fulfill that contract, and you return back to the private under common law. That's how it's always existed. See, I don't know if you guys had a chance to watch that second short that I made today. I didn't have a chance to cue it up here, but maybe I'll play it. Let me just put it into my media files, because this actually explains what I'm talking about how ancient all of this is and how ancient their plan to usurp essentially God's jurisdiction has been. And I know people will be turned off, like, oh, he's a Bible I'm not a Bible thumper at all. Trust me, I'm the farthest thing from it. But what I will tell you is that all law is based on the understanding that we are all created beings. And that is the sovereign fount of authority, is the creator. And I don't care what you have to say about that, because if you do not know that, then you'll never be able to study the law, ever. You just never will. And so let me just drop this in here real quick, and then I'll play it for you guys in a second. But
that's also why a long time ago I brought up the fact that they pretty much stopped teaching Latin in school. Like my grandma knew Latin, but yeah, you can break down a lot of words and definitions through Latin. And I think it's just another way, they use a lot of the Latin language in this legal stuff. So, they do that because a lot of people aren't hip to it anymore like they once were.
That's absolutely right.
Like register, right? Of the king.
Yeah, well, almost anything you can break down, yeah.
Right, because register, regal, exactly, the king. So, let me see here. Okay, it's taking a while to load, but it will. Said you're back. Oh, there he is. Okay, he made it back up here. What's going on, Raj?
Oh, just having a lot of PC problems, and I actually talked to the CEO of ALE today, oddly, right before my computer went, but it's back up and running now. So, yeah, that was a fun conversation I had. You have no idea. I'm doing a stream later, so I'll let everybody know what happened.
Okay, yeah. Do your
cool
thing. Yeah, that's cool. I'll have to check it out. I'd be interested to see what they said.
Oh, yeah. You'll get the idea. They're in bed with a couple other people, you might say.
How could they not be, right?
I know. I was going to say the reason they use Latin a lot to hide their intent. Most people aren't wise to it. That's what I've gathered out of like sitting in courts and being raised in the Catholic Church, for that matter.
Absolutely. Yeah, you're absolutely right. So check this out. This is how old this is, how far this goes back, and it's literally It's the only, now you have to remember, you have to have the understanding. I had AI analyze so many books, right? Books that I've read, like Rulers of Evil, Tupper Saucy, Blackstone's commentaries. What else? Hold on. Oh, the Pied Pipers of Babylon by Verrill K. Spears, who has a doctorate in common law. It's a fantastic book. All of those books are in the Jurist Society folder as well, by the way. And I do recommend that everybody read them, even though I know they're all big books and they take some time. You will benefit immensely from reading those books if you want to know how long this plan has been in the making. But it's simply this: from the dawn of civilization and the first city being built, right? Man cannot make law, but has always sought to control their own kingdoms, right? They've sought to control God's creation. So the only thing they can do is regulate property and regulate commerce. That's it. So the Babylonians were the very first ones who figured out how to introduce taxes in the form of tributes. Okay, we're talking all the way back to Hammurabi and the Tower of Babel. Introduced taxes in the form of tributes, and were the first people to reduce people to chattel property by contract. That's where it started. Then Rome took it up a notch and said, okay, we're going to continue of course, Greece and Persia advanced the Babylonian system, but it really took off with Rome, where they introduced the concept of citizenship, okay, as just an automatic justification for taxation. And the way that they did it was they're like, hey, you want to be a Roman citizen, like how Paul was a Roman citizen. You want to be a Roman citizen so that you can have all these benefits of being a Roman citizen. But being a Roman citizen comes at a price. You got to pay that Roman citizen tax. And so they offered this illusory benefit situation, ultimately the predecessor of the 14th Amendment, if you ask me. And a lot of people call the 14th Amendment the Pope's Holy Roman 14th Amendment. It's what it is. And so, because it's all taking place, they're the ones who put up the public charitable trust that backs the Social Security in the first place. That's the Vatican. They do that shit. So it's all the fulfillment of the papal bull Unum Sanctum. We're taking the whole world in trust under administration, acting on Christ's behalf till he returns or whatever. That's what he says in the papal bull. Those aren't my words. Those are his words, not verbatim, but go read the papal bull Unum Sanctum by Pope Boniface VIII if you don't believe me. So anyways,
Ryan, that's a bold claim.
About
Christ
yeah. Oh yeah, hell yeah, it is. Yeah, absolutely. So they took anyways, so they what the hell is this? Okay, so they introduced the concept of citizenship, right? And that was Rome. And then it moved to London, where it was perfected throughout the Middle Ages with the introduction of the feudal system. So now see, after Rome fell, their governance, their established governance still continued under the church in the form of canon law. That's what's interesting about it, in the form of canon law, right? And so they started introducing taxes as tithes, and they still controlled property by bringing all the kings under them, and then establishing parish jurisdictions within each of the European countries, and then still had the Roman fiefdom and controlled everything that was going on behind the scenes. And that's ultimately what led to the rise of the bankers and the banking system in London and the feudal system in London, where all property ownership went to the king under William the Conqueror, and then the king could regulate the use of property, right? So he gifted it back out under title, baronies, and knights' fees, and all this stuff, right? And they all came with obligations and man-made law that use of that property subjected those individuals to that man-made law. And that's called feudalism. That's what we live in now, neo-feudalism, where the United States is the fief holder, right, of all the property, and you always have to pay property taxes to some feudal lord, and it ultimately all finds its way back up to the top because you don't own anything. Everything's under administration and held in trust. So then it moved to London, right? And the American Revolution was actually an authentic attempt to get free of it, that they actually hijacked, these usurpers hijacked that movement. And that's why the Constitution replaced the Articles of Confederation. They had to do something about it. They had to do it quick. So they introduced the Constitution, which left the back door open for the same bar association that introduced feudalism into Europe, and the same lawyer merchant fucktards to go ahead and usurp our sovereignty through the judicial branch of government, right? And it all started with this unelected tribunal of black robe PDF files that we call the Supreme Court, where they think they can interpret the very instrument that created them. That's insane. You can't interpret. The Constitution created you. Who are you? That'd be like me. You know what? I think God fucked up when he wrote this. So I think he really meant that. Yep. And that's, you know what? From now on, when you read this, it means that. Who gets to do that? No, you don't do that. Right. So I hope that makes sense to everybody. Check this out. All right.
What if I told you that the world we live in, courts, taxes, debt, and constant surveillance, isn't just random chaos? It's the result of a single unbroken plan that started in Babylon, refined in Rome, and perfected in London, now running through Washington, D.C. In Babylon, they figured out a crucial truth. Control the measure of value, and you control the people. They created debt contracts that turned individuals into property. Fast forward to Rome, where citizenship was a tool of conquest, and every conquered people became a taxable asset. When Rome fell, its legal system morphed into the church's canon law. By the time we hit medieval England, the City of London was treating land and people like cargo. Common law was being overshadowed by admiralty law, all for profit. The American Revolution aimed to break free from this, but the debt to London bankers lingered. Then came 1933, when the Great Depression gave President Roosevelt the excuse to seize gold and mortgage every American's estate. Your birth certificate became a trust, and suddenly, the U.S. was a corporation in receivership, with administrative law replacing common law. Now we're in the final phase of this plan, where every transaction, movement, and thought is measured and controlled. This isn't about justice or safety. It's about replacing divine law with man's administration. The question isn't whether this plan exists. It's whether you'll live under it or step outside it. Learn how by searching Burn the Corporate Fiction on YouTube, Rumble, Facebook, and X.
Unmute Cubby there.
Yeah, sorry about that.
Yeah, your
You're on
mic
mute.
for some reason.
Is it still messed up?
You sound good.
No, you sound good. It was just for some reason it muted all of our mics when I played that. But it left,
I hit a button. I didn't mean to.
Oh, it's all good. But no, yeah. What do you guys think of that? Because that's the truth.
Yeah, that's interesting. That explains a lot why the Supreme Court, what you were saying earlier, is quite an event when they appoint a new one, and why they don't have like really limitations. It's like a lifetime gig, right? They make their own rules. The Supreme Court, and it's the highest held position in the land, pretty much when it comes to what law, civil law.
Yep,
they determine most of those rights.
We'll see, and now they make rules of procedure and equity, which they never were supposed to do. There's not even supposed to be established rules of procedure for equity, because equity is supposed to be a case-by-case basis, and it's supposed to be special circumstances, right? Like adjudicating a trust arrangement or a contract, or even just an implied trust arrangement or contract where, like, if I save your property and I take the stance of like, oh, well, you wouldn't have your property if I didn't save it, so you owe me. And I'm attempting to seek equitable relief, right? Because I'm implying that there's some sort of debt was created, some sort of contract was implied by what I did. And that could only be adjudicated in equity, because that's all make-believe shit. I'm making that up. I'm interpreting that. I'm using human reason to try to justify you giving me your property based on things that did not happen, right? So what I mean by that is it's pretend stuff. So I'm saying, well, if I didn't stop your house from burning down, then you would have none of this property. And so because I stopped your house from burning down, you owe me some of your property, because you would have lost it all without me, right? So see how I'm using like things that didn't happen, could have happened, the world of pretend, right? To try
hypothetical, yeah.
Yeah, well, the law cannot do anything with that, right? The law cannot do anything with that. If I took that to a court of law and was like, hey, you know, his house was burned down, I stopped it, and if I didn't stop it, he would have nothing, so he owes me some money. And the law would be like, well, did he hire you to put his house out? No. Oh, did he ask you to? No. Okay. Did he tell you he would give you some money? Or is it in a contract? No. Then no. What are you talking about? It's all make-believe shit that you just said, right? He doesn't owe you anything. He hasn't agreed to give you anything. That's how the law works. Law cannot deal with pretend stuff, right? Like if it should, Chad, you can, I'll tell you what, you want to be the trustee of my car, right? You've got to maintain the oil at your expense, maintain the gas at your expense, but you can drive it wherever you want, but it's still my car, right? Now, the only caveat is that you cannot drive it after 7 p.m. or before 6 a.m. Okay, so that car from 7 p.m. to 6 a.m. better be in the driveway, right? Now, if I want to go enforce that, I can't take that to law because you agreed to it, so it's drawn up in a trust instrument. The car is placed in trust. You're the trustee, right? And I'm the grantor. Okay, cool. So that's all drawn up into a trust. All right, now I can't enforce that trust at law because it's not law. And just because you violated like the terms of use of this property that we agreed to in this trust arrangement, the law cannot do anything with that because it's not a crime. It's not a crime. You didn't hurt anybody. You just misused the property. You didn't hurt anybody, right? And so the law cannot deal with that. And that's why it has to be adjudicated in equity. And what happens in equity? The judge is God. And because it's make-believe stuff that's being decided, then the judge gets to use his own conscience and his own equitable principles to decide how that should work. And he gets to act as a King Solomon up there, right? But now that everything is adjudicated in equity because everything is held in trust because you cannot buy anything and everything's held as collateral for the mortgage, right, of 1933, the judge is always God. The judge isn't just deciding what's equitable. He's controlling your life.
Man, they get you over a barrel from the go, don't they?
Yeah. So it's pretty wild. But all right, let me address some questions. I'm going to have to shut this thing down here. Let's go back. It looks like there's been a lot of, let's see, there's been a lot of comments. So say, haven't been feeling good for a week. That sucks, Pat. You all right, man? Damn. Hopefully he's
Get some of that horse toothpaste. I'm no doctor though.
Yeah. Go ahead and yeah, exactly. Do that. He's right. No, I'm serious. That stuff works. I've taken it.
I put it in a soft gel and just swallow it.
It works.
Just go by your body weight. Just go by your body weight.
Yep. And you can't. Well, we're not going to give medical advice.
Yeah, we know what you're saying.
Yeah.
Quick question for you, Chad. Where do you get the toothpaste at? That's my question.
Like a Tractor Supply store.
Yeah. And it's not actually toothpaste, right?
Yeah.
So, well aware of this thing. Thank you.
Okay. Just making sure. All right. So if liberment, so let's see here. Peaceful Penguin says if liberment were a real Latin word, it would most likely mean the act or process of freeing, the state of being freed. Well, the funny thing about liberty is it's actually a maritime term. It's an admiralty term, and it's basically when you get leave to go ashore is what liberty actually is. But yeah, I get what you're saying. How long, oh Lord, Benji says. Absolutely, dude. This is a spiritual battle. There's no question about it. It's exactly what they're trying to do, and see if they can get you locked into this trust indenture by integrating your what people call straw man, even though I hate that term. It's a legal entity identification. It's what it actually is. And it's a legal fiction. And if they can integrate that into your physical being via some sort of nanotechnology or whatever, so that you are, and then place AI governance and digital currency into play, where no matter what, this thing's in charge of governance and it only sees that legal fiction. It doesn't see living men and women. Then you're permanently locked into the beast system, into hell. And that's why I think that's what the digital currency combined, none of them by themselves are the mark, but all three of them combined, the social security number, the AI governance, and the digital currency, all combined are going to be what you need to buy and sell and what traps you into the beast system 100%. That's where they're heading with this. So let's see, we got the word Lord originates from the Old English word. It's two consonants together. Without Hlaford. I'm sure that's not how you pronounce it, but that looks like an old like Norse or English word. Yeah, Germanic Norse. Anyway, which evolved from, it's definitely a Nordic word. Hlauf, weird. And so the funny thing about that, the term allodial comes from a Nordic principle. The Vikings brought a real sense of the power of the people and of sovereignty to England in the 800s AD. When they came over there, and they brought the concept of allodial title, and what it means is like all oath or all blood oath. It's basically a blood oath. And what they would do is actually cut their hand and mix it with the soil of the ground that they were taking ownership of. And it was basically like a pledge to the earth that you'll be a good steward of that land. And that's how you could hold it to your bloodline forever. And it became yours allodially because your blood was mixed with it, and you gave a blood oath to that land to have it. And that's where allodial actually comes from, if anybody is interested in knowing that. The Roman civil law version of an allodial title is called a perfect title, which essentially is the same thing, but just without all the cool spiritual understanding behind it, because Romans are douchebags, slavers. So, all right. And then so we have, it means loaf ward or bread keeper, which would make sense, like the one who provides, right? So, let's see here. What else we got? Any other? The appellation lady similarly deprives from bread kneader. That's interesting. I do love etymology, and I think everybody should study it, especially if you like studying law, because then you can really break down what various words mean, like contract, right? Con like concrete, right? Yeah. Or it's a bringing together of something, right? And then tract is obviously like a path or so you're basically bringing two people together onto the same path, right? Contract, essentially. But all right, let's see here. The Norman conquest of 1066 significantly institutionalized the, I would say, feudal. Yeah, it's absolutely. Well, what it did was it introduced the feudal system into England and gave all ownership. The way they did it, they used common law to introduce feudalism. That's what's crazy about it, is the way that they did that was because the nobles all had a allodial title of their land prior to William the Conqueror. And then after William the Conqueror came and conquered, he let Denmark come and invade, basically. Well, that's not what history says. It just says he left and Denmark came and invaded, but they had no military because the conqueror took their military and their military law. They only had their common law. They couldn't mount a defense, and they got, occupied for a little while. And then Denmark left, and William the Conqueror came back and was like, hey, and I learned all this from Blackstone's Blackstone's commentaries, reading the books, well, audiobooks, listening to them. But says, so he came back and said, hey, you guys got your ass kicked. You have no military law. Guess what? I can fix that. Why don't you introduce what we are doing all across the rest of Europe into your British Isles? And it was feudalism. Basically, feudalism itself, which we're still under, is a military martial form of law, where someone has an interest in everyone else's property, which causes them to mutually protect one another, right? So what they did, and what he convinced them to do, he said, okay, so you guys all own your land now, right? And the king has no say or interest in it. He has no interest to protect or anything. It's not his land. So what you do is you give it to the king. You register it in this land survey book, right? And you give it to the king. Now the king has the controlling interest of the land, and he'll gift it back out to you under title. And remember, man cannot make law, can only regulate and control property and commerce. So now with the king gifting back, or getting all the land under his control and then gifting it back out under title, the king was able to make law. And that law was feudalism. And the law was basically like, hey, you're an earl, you're required to, or you're a baron, you're required to hold a manor. On your manor, you must have a church and a parish jurisdiction. And you must hold court to settle disputes between your tenants and serfs and all that, right? And your knights and stuff. And you must pay me rents and profits. And you must do this with it. You must do that. And then in the event we're attacked, you have to conscript this many knights and this many soldiers and all that stuff. And the king could now do that because he controlled all the land. So the baron or the nobles didn't have to enter into that, but if they wanted the land and they wanted their stuff back, they're like, okay, well, give it to me. Now it's yours, and I hold this title under you, but at least I got my stuff back and I can use it. But that's it. That's the only thing, is use it. And it's called a usufructuary, and it's a form of usury. And that's what creates feudalism, is usury. Usury creates feudalism. That's how we're in this situation right now, where the county has taken, or the corporate state has taken all the land through the Torrens registry system and through obviously usurping the sovereignty of the citizens and taking them under administration. And now when you buy land, even if you pay it off or think you do, you can't actually buy anything because you don't have money. You just have negotiable instruments. And secondly, you don't own it because of that reason. You still have to pay your feudal lord a rent every single year. You have to pay feudal fees every single year. Otherwise, they come and they take their property back because it was never yours. You just got the right to use it. That's it. And they come take their shit back. That's not the case in this country. Wisconsin Constitution, Article 1, Section 14 says that all lands are allodial and feudal tenures are prohibited. And that goes for all states because Article 4, Section 2. Okay? All land in this country is allodial. We're not supposed to have feudal tenures, but the bankers taking over, the bankers taking over the federal corporation, the federal corporation territorially occupying all the states by usurping its citizenry and creating federal areas using like social security zones and all that shit, has created a neo-feudal system where the supreme property, the controlling interest of all the property is King United States. Now, it's the same system. So anyway.
Eminent domain.
Yes, yeah.
Fifth Amendment, yeah.
So Crip says, not many go in this much depth and teach as well. Thanks, man. I appreciate that. I do, sincerely. It's taken a lot of work to learn it and learn it well enough to explain it as simply as you can explain something like this. I know it's still not very simple, but I try. Pat says, government Satanists known as Congress voted 302-4 to continue to give Israel trillions in aid. Miga. That tells me there may be 4 Christians in Congress. Yeah, that's interesting. We showed that on my dad's show the other night, that Charlie Kirk getting cornered by that guy talking about the Talmud, about what it says about Jesus. Yeah. And then all Charlie can do, he was sitting there short circuiting on TV. Yeah. And then all he could do is be like, well, those are all legitimate verses, but God blesses those who bless the Jews. It's like, what, dude?
Yeah, he's just being groomed to be a politician one day. That's what all that Turning Point USA stuff's about. It's just the next generation of Republicans, basically.
That's a good point, actually, because over in so it's controlled by the Pilgrim Society. Candace Owens. I actually learned all this from investigating Duffy and them guys. But Candace Owens, when they had her promoting their TFE stuff, her husband is the son of a lord in England who's a member of the Pilgrim Society, who's involved with the creation of Turning Point. So imagine that.
Yeah.
Right? Yeah.
I think. Yeah.
Something Farmer. His name, Michael Farmer.
Yeah. Farmer. I can't remember. Yeah.
It's Farmer. Yeah. Lord Michael Farmer.
Yeah.
And, and over in England, they have a Turning Point over there, and it's something entirely different. It's not nearly as conservative as it is over here. So it's a chameleon. It adapts to what it has to be in its native environment in order to trick people into thinking it's on their side, so they can subtly manipulate circumstances and, ultimately get what they want. But yeah, make no mistake, none of them are friends of this country. It's not real at all. So, let's see.
Did I ever give you that link about the Pilgrim Society? Let me see if I can find it here. Shoot.
Yep, that's true. It says the word Satan comes from the Hebrew word, which I don't speak Hebrew, so I don't know what that or read it either, but I believe you. Meaning adversary. Satan is an adversary. Absolutely. So the prosecutor, when you're in a court case, it is a mock-up of Judgment Day every single time, and the judge is sitting in the position of God, and the prosecutor is supposed to be the adversary, is supposed to be the devil accusing you of all these things before the throne. And that's why it's a Babylonian black magic ritual every single time you step into court. Nobody finds it weird that the judge wears literally a black ceremonial robe every time he walks into the courtroom. Nobody thinks it's weird at all, right?
Well, don't they in England, don't the barristers wear robes too, from what I remember?
100%, yeah. And it's all a Babylonian black magic ritual, man. Oh, we lost Cubby. Yeah, we did. Yeah. It's all Babylonian black magic ritual. And make no mistake, let's look at this. What did they call the AI for lawyers? Spellbook. Yeah, spell
Funny.
book. Well, it's because it's what it is. This is the real, I believe, the real Tower of Babel. And it's just my opinion. I can't prove this. It's just my opinion from what I can prove about the law and know about the law and the way law works and how man cannot create law specifically because that is only in the domain of the creator. And so they regulate property. And the very first regulation of property and turning people into property via contract happened in Babylon. So I think the very first Tower of Babel and trying to reach quote unquote heaven is actually just trying to usurp the jurisdiction of heaven using commercial law. That's what I think it is.
Well,
and I think
when I first got into this arena, we actually did a search for the real actual geographical spot of Babel. We found some interesting stuff that actually kind of led us to this one spot. And PJ did a show on it, and Michael Kahn both did. And it was kind of revealing that where it is.
Interesting. I'll have to check that out. From
I'll have to dig it up.
So.
PJ Cruikshank.
Yeah, I know who he is. I watch his stuff sometimes.
I put a link in the back. I think it's back. You saw that?
I'm busy trying to copy and paste it over there. My dumbass copied the link I was trying to paste over, so it was kind of dumb.
I was just curious if I had sent that to you before, if you even looked at it.
I don't know. I'm going to take a look at it right now.
Yep.
Paste. Okay. ISGP studies. Pretty sure my computer's about to blow up on me. I have so much stuff open. Oh no, I have not seen this.
Yeah, it's pretty interesting. I don't know when it was last updated because the guy that made the website or whatever, he hasn't really done anything in a long time, so I'm not sure. But there's still a lot of good information on it nonetheless.
Yeah, so that WASP, White Anglo-Saxon Protestants, yeah, that's definitely Charlie is a WASP, no question. Hey, we got sketches. Emphasis on the neo-feudal, Mr. Obvious says. Good to see you, sketches. Yeah, absolutely. Peaceful Penguin says, thank you for caring. I'm not the only one. We all care up on this panel, and all of you guys care. So I thank you guys for actually wanting to learn this stuff. None of this will change. You know how hard it is to talk to people about the dry subject of law and how important it is to your everyday life and what they're doing, this like trap that they're setting up, the satanic trap. They're just closing in around everybody. Nobody sees it because they don't know the law. If you knew the law, you'd know this. But you know, people, they have no interest in it because it's so dry and boring. But then once you see it, like I'm showing you guys, you're like, holy shit, yeah, they are like, we're like 2 seconds from midnight right now with what they're setting up. This is like, did God already come and leave or something? Did we get stuck in hell? What's going on here? That's sometimes what I think. I'm like, shit, they're already way farther along than anything I've read in the Bible. They're about to set it up like right now. As soon as they get that. Go ahead. Yep.
Oh, I was just going to say that's the whole point of it, is it to make it like that. It's just like we were talking about earlier with TOS. You know, it can be pages and pages and pages long of all legalese and, you know, law speak and everything. And until somebody that knows what they're talking about comes along and points it out, it's like, holy crap, I agree to all that, you know.
Well, what I try to do is
they get arduous, don't they? They really do. They don't want you to do it.
Well, why do you think that they do not teach the law? So they say ignorance of the law is no excuse for breaking the law. Well, then why the hell don't they teach you the law in school? Well, I'll tell you why, because they don't want you to know the fucking law. Because if you knew the law, you knew that nothing they do is lawful.
Mm-hmm.
You'd know that they're a bunch of illegitimate usurpers, a bunch of demons, right? That's what they are. They're a bunch of greedy, selfish, a lot of times buggers, right? Pillow biters. And it's I mean, I swear, you guys seen that show I did on that. It's almost at the bottom of every single one of these freaking conspiracies and schemes. There's some sort of donut puncher, dude, every single time. So I don't know what that's all about, but yeah, what's
they call
true.
it the criminal justice system for a reason. It's criminal and it's just for them. I don't know.
Well, it is, man. It is. So Benji, yes, it's definitely let me know how that goes, and check for the notice of liability, or notice to file on demand in the WordPress or in the Jurist Society folder, and take that with you just in case as well. And what I would also do is you can take that template of the Jurist Society, the notice of demand to file, right? File on demand, and I forget what I titled. It's basically a file on demand though. And every law has the same thing because the position of clerk is universally the same. It's ministerial. And because it's a ministerial office, they only have the right to determine the format of the paperwork, but not the contents. Though, like Muskegon, where I'm at, they tried to say, well, you can't have this in it and can't have it. And I was just reading, I was like, oh, yeah, I would like to see you enforce that because you have no, it's against your own statutes. You can't tell me what's in my documents. My document, I need it on the public record, and it's none of your business why or anything. Your job is file it. That's it. And you tell me, okay, it's got to be this font, it's got to be this spacing, and then you have to have these margins. Okay, cool, fine. And then, so like my county, I looked up their requirements, and that's what you have to do, look up the filing requirements for your county register. And so they wanted like 2.5 inches on the top of the first page, and it looks really stupid. But that's what they wanted. So I put a top margin 2.5 inches. So there's a big, on my actual claim, there's just a big old giant blank space in the header for no damn reason at all. And they're like, oh, it's for notes or whatever. Yeah, okay.
To stamp something there.
Right. What it's actually for is so that like people don't know that, go up, try to file something, and then go back and have to redo it because they didn't know it. Dicks.
Put you back to the ringer again, huh? Just...
Oh shit, we got Peaceful Penguins, got the damn Tony Montana over here. All I have in this world is my balls and my word. I don't break them for no one. You know, it's awesome. We got what's stopping them from having total control? A couple things, which is why they're trying to develop the AI weaponry through Palantir, because that will be a match for us. But right now, they would be no match for us in the Second Amendment, and they know that. And that's why they've only ever pushed so far here in the Republic. And in other countries like yours in Canada, because I'm pretty sure in Canada, right, Rick? And UK and stuff, they've pushed way farther, as you guys can see, because they have no Second Amendment, but they can't go all the way as long as our republic over here still stands. They need every country to be under complete administrative control and disarmed. And so what I think they're planning on doing here is implementing that AI against us. It's just, I have a feeling. That's why they're so concerned with developing this AI weaponry, and then other AI products like Gotham that can target dissent, basically. Like, so you got to understand everything you're doing online, all the social media, the fact that you're watching this podcast right now, all this is getting filtered, all this data is getting filtered into an AI. And the AI is organizing all the data and creating complete personality profiles of each and every single individual that it has access to. And AI is so advanced. We're talking about a learning model that can read all 4 books of Blackstone's commentaries, like over 1,000 pages in a second, right? This thing is calculating what you will do in response to various stimuli. You know, if we do this, what will they do? If we do that, what will they do? How many people are actually, you know, yeah, you've got the Second Amendment, we've got all these arms in the country, but how many people actually use them? Let's see what that is. And the AI can very accurately predict all of these different strategies and models based on what the data that it's getting, because that's how much data we're getting. I mean, there's people who post when they go take a shit on their Facebook. You know what I mean? You spy on yourself. So we're giving them so much data. You know, well, I don't either. I just post stuff that's a pain in their ass. And but yeah, we're giving them all this data, and they can accurately predict all this stuff. And so once they get that fully implemented, then I think they're going to make their move, which is why I'm trying to do what I'm doing, and other podcasters and you guys, everybody, you go and you tell people that you know and try to wake people up. We're doing everything we can to wake a critical mass of people up before they fully implement this in the next 5 years. And I think we have a good shot, because that's why they're so panicked. And I think that's why they put in the Trojan horse of like, okay, well, you know, Kamala gets in, it's going to be absolute collapse and all this stuff, right? So now Trump won because the majority of people stood up and wanted, like, we're talking about the voting block in the country. They couldn't rig it and put Kamala in. They're like, okay, so we have to go back to the drawing board for a minute, but at least that's our plan B, and he'll continue to move things forward to a certain extent until we can get this AI developed, and then boom, you know what I mean? So that's what I think the situation is. I think it bought us a little bit of time but not much, because he's still just moving right ahead with all the plans. The only difference is that we're not going to be occupied by China immediately anyways, in my opinion. So
the only thing about AI is that it's based on the human experience, right? Like it doesn't have memories, it doesn't have emotions. So I think it's like limited in that factor. Like I don't know how far, once it runs out of material, it's not like it's going to create it. I mean, that'd be scary if that's what it does, but it's not going to create its own memories and its own emotions, because it's not. It's just limited to what we experience. Whoever created the software. But I mean, I don't know.
I don't think it's, I think that it's, I don't know, it's potential, if it's even actually, who knows what the thing actually is, but I've interacted with it a lot, and it impresses the hell out of me what it's capable of doing and producing. Pat says he's going to do the same shit she was going to do. I both agree and disagree. I disagree to the extent that the plan, if she won, things were going to happen a lot more quickly. I know that, but that was, of course, that's what all elections are. They're the litmus test. They're the testing the water, seeing how ripe for a sodomization are you? You know what I mean? And because the conservative people in this country stood up in huge numbers, then I think that they had Trump prepared as a plan B, where it's like, okay, so we're not going to get away with it right yet, but we're going to, that's why he's a plan B, dude. He's still an oligarch. So he's still going to further the agenda, right? I absolutely agree with that. But he's just going to do it much more in a much more subtle fashion while placating the conservative aspect of society. And I think that entire thing was a result of AI learning and strategizing by having access to everybody's data. They knew that their odds and probability of success with Kamala were not as good as they would be if they lull everybody back to sleep with Trump and then spring the trap.
Yeah,
that's what I think. I honestly do. And because he's sitting there, he's saying all these good things, and some of these things he's doing is good, but then other things like the hiring Palantir and giving it the largest military contract, the big beautiful bill, and then signing the sovereign wealth reserve, which is going to turn you into a digital asset-backed currency. Essentially, instead of being mortgaged to the Federal Reserve, you're just still going to be mortgaged to the United States corporation. They're going to create an asset-backed digital currency, and then that also opens the door for a universal basic income, because that asset-backed treasury dividend dollars. So the dividend then is they're going to give you a dividend. They're going to be like, yeah, we use you as an asset for the currency, but here, we're going to give you a cut of it now. See how good we are now? We're giving you a slice of the pie that the bankers had. We're going to give you a little, but all that little slice of the pie is going to be is a fucking universal basic income as AI comes in and takes everybody's jobs.
Yeah, I think that was a lot of what that U.S. debt clock PDF or whatever was about too.
That's the conclusion I've come to also. Yes.
Yeah.
Guys, don't you think they're using that for social engineering too? I think it's a big key in the AI thing. They're getting to learn everything about you, your social behaviors, and they're going to be able to use it without conscience. Just stick it on people, literally, like a dog.
See, what they're really hoping people like us start buying into that shit. Like how surprised I was. Like, I can't believe that they're actually showing people about this, the banking system. They're exposing. They weren't naming any names. They weren't talking about Meyer Amschel Rothschild or the Rockefellers or Carnegie or any of the Italian papal bloodline. It wasn't talking about like that stuff, but it was telling people how the banking system works, right? And it's like a huge red pill for anybody who goes on a debt clock. And so it did impress me at first, but then I started thinking about it. It's like, oh no, they're trying to trick people like us into thinking, oh, the white hats are going after the black hats like the Q-tards do, right? No, they're all the same. They're all the same fucking group of people trying to usurp God's jurisdiction. Either way you cut it. Trump has no interest in returning to common law and the original republic. He loves the commercial system. There's one Time magazine thing that said, I'm the king of debt. Had him on the cover, said Trump's the king of debt. Well, what does that mean? When everything's debt, right? He knows how to manipulate the security system, the mortgage-backed security system or debt security system, whatever you want to call it. because they try to say, oh, well, Larry Fink created the mortgage-backed security. No, motherfucker, the Federal Reserve created the mortgage-backed securities in this country, because that's exactly what a Federal Reserve note is that's a mortgage-backed security. 100% by definition, that is a mortgage-backed security.
I think that's why YouTube sends out all those the Ian Carrolls, the Candace Owens of the world, to run that narrative that you're just talking about right there. At least that's what I think. I don't know.
That's true. No, I do.
Yeah.
I think to a degree, those people like Ian Carroll, I think Ian Carroll was sincere when he started, and now he's gotten big and he's stuff. And so he's trying to find a niche that's not going to get him in too much trouble. I guarantee you when Candace took him under her wing, the whole Pilgrim Society situation had a talking to with him or something to that effect, and was like, hey, look, what you're doing, that's all well and good, but only if you do what we tell you. Called controlled opposition. You know what I mean?
It's just like the government, the Republicans and Democrats are both the same, two sides of the same coin.
Right. So, and that's
they play the good guy, bad guy, the good cop, bad cop thing all the time.
Well, that's the thing that confuses people in this system, is they think that these people don't actually fight with each other, but they do. Who's got me on their YouTube or something?
What's that?
Is it? Do you got your YouTube on, Cubby?
Yeah, I don't. I can.
Is my YouTube on somewhere? Oh, there it went away. Okay, yeah. So it had to be echoing out. Okay. So, anyways, people don't realize. Yep, it's echoing.
Is it me? Okay.
Yeah, just mute it when I'm talking, then when you talk, because I'm gonna shut it down in a couple of minutes anyway. But people don't realize, they think that these people do not actually fight. They do actually fight with each other, but they're ultimately working towards the same goal, which is establishing a satanic material commercial system and locking everybody into it, basically usurping law. That's their goal ultimately. And they all work together on that because they all work for the same people. They're all the bloodline of fucking Cain, if you want to call them, whatever, serpents, whatever the hell you want to call them. They all work for towards the same end, which is that, to create this one world commercial oligarchy and usurp the sovereign authority that rightfully belongs to God. But they do fight with each other internally because they're savage people who eat their own, right? They do fight with each other internally over who's going to run it, who's going to be the top people in it, who, they're vying for their positioning in this new system. So they are legitimately fighting each other, but they only fight each other on certain issues that basically regard their positioning in the New World Order. And then on everything else when it comes to enslaving you and barring your access to law and placing you into this new digital indenture, all of that stuff is they're all working together. They're not fighting at all. And so, they just basically take turns pushing it further. So you keep switching your anger from one party to the other. It's like a pressure relief valve. So it never builds up all the way to the point of revolution like it almost did recently. And that's why they kind of backed off for a second. But now that they've placated most of conservative MAGAs into complacency again with what they're doing, talking about locking up Obama and all that stupid shit that'll never happen. That was the point of it. They just wanted to lull everybody into complacency, and now they're still moving forward with the same digital debt system, the same AI governance, the same freedom cities, right? The same things, all the same shit, and it's didn't skip a beat, it just slowed down a little bit, and that's where we're at, and that's why it's so important that you claim your estate and put your property in a private express trust, which I'm actually working on a way to try to figure out how to include intellectual property into that, which would include like data and stuff. There's got to be a way that you can classify data as a form of property, because it's my data, right? And put it in a private express trust. But then again, all the contracts that are linked up to the use of the internet, or even to just be able to teach you guys, would automatically nullify that express trust and place the trust itself under contract with the fucking IT company. So that's a tricky one I'm working on. But all the rest of it, though, placing your actual property in trust and making sure it cannot be used for commercial purposes after you've claimed your estate and removed it from the indenture in the first place, that's the key. And then you become a massive pain in their ass. And just like Sergeant Frog Dog, you can get the MCO to your automobile, because you don't want to call it a vehicle, and you can get absolute title to all your property. And then there's nothing they can do. They can't force you to register. They can't do nothing because you put that stuff in trust and specifically expressly state that it cannot be used for commercial purposes. And that's the key. So with that, I'm going to shut this down tonight. Do either of you, Chad, Faye, have anything you want to say to the audience? I know we lost Roger, but he's having computer problems. So he said, good show.
No, I was just going to say thanks for having me up. Yeah, a lot of good information.
Thanks, Ryan.
Yeah, absolutely. Absolutely. And Mike, email me, burn the corporate fiction at yahoo.com if you do not already have the Jurist Society folder link. Because I believe you're a new member, unless it's Grouch over there, in which case you already have access. But if you do not burn the corporate fiction at Yahoo, I will give you access to the Jurist Society folder. And Faye, tomorrow night we are meeting at about 9:30, I'm thinking, so that you can make it and everything.
Okay, thank you. Yes, I will be here.
Absolutely. And to everybody in the chat, thank you for being here. Thank you, Chad, for coming on, even though you took off. And thank you, Roger, for being on. And I hope you guys have an excellent night, morning, whatever it is for you. I'll see you probably tomorrow.